The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we're going to hear today is Hauk versus Life Store Bank, and I guess Mr. Perry is. We'll hear from you first.
Your Honor, may it please the court. I am Shane Perry for the plaintiff Hauk, the plaintiff appellant. Would Your Honor
want to keep your voice up? I don't know where your speaker is. Do you have a speaker there?
Yeah, it's right here, Your Honor. Can you hear me now?
Yeah, that's getting better. That's getting better.
I'll project more. I apologize, Your Honor. Would Your Honor like for me to start with the appealability argument or go straight into our appeal?
Well, I can tell you the overarching issue seems to be that we had a final judgment in February of 2014 when the two second defendants 2 and 3 were dismissed, and that wasn't appealed at the time. So the question is, should we somehow be hearing it again today? I think that if you were able to put that to rest, that would help a lot.
Thank you, Judge Neumeyer. I'll do that. There was a final judgment document filed in 2014. The Supreme Court in Bankers Trust said that there is a requirement. We must have a separate document that is final for all claims against all parties. There should be a mechanical application of that rule, and the rule should prevent the loss of the right of appeal and not prevent or facilitate the loss of the appeal.
But let's get the facts a little bit straight and see if I understand them. You appealed defendant 1.
Correct.
Interlocutory appeal, because
Yes,
defendants 2 and 3 were still in the case. Defendants 2 and 3 were dismissed in February of 2014. And under our cumulative finality doctrine, we finally had jurisdiction as of February. When the 2 were dismissed, that wasn't appealed. So all we had before us on appeal was defendant 1. We vacated the order on defendant 1 and sent it back to have defendant 1 subject to trial. The case was tried, judgment was reached, settlement on the judgment was reached, and that ended the case. Tell me what happened after that.
Well, there was a part in the middle there. When our appeal was first sent back, Your Honors found that there were still claims open. It was in the order that we were.
Except the order directed us only to retry the October 14 order. We only addressed the October 1, 2013 order. That's all we addressed on appeal, and that's what we sent back.
That is correct, Your Honor.
There was no issue before us on defendants 2 or 3.
That is correct.
They were dismissed. So the only thing decided by us was to send it back to have a trial on defendant 1.
Actually, the court said that there were still claims open against Grid and Life Store, and that's why it was sent back. And then,
well, how could there be claims open? They were dismissed.
That was in the order. That was in the opinion.
Where did we say that? What can you point us to the language that you're relying on?
That is in the order from 2015. If you go to, I don't have that order separate. It was a footnote in the order, in the opinion from 2015. If you give me 1 second, I'll find it for you. I think it's in the 160s. It says, because there are still claims pending, and this was part of the whole case below. There was a fight about that there were still claims pending. If you look at 146 in the joint appendix, I'm sorry, that's not the one.
You want me to hear you want to hear the mandate?
Yes,
The
Your Honor.
judgment of the district court is vacated. The court's October 1, 2013 order dismissing Houck's claim against the substitute trustee is reversed and the case is remanded for further proceedings.
That is correct.
All right.
And the problem that we had in the lower court was that there was a footnote in the order that said that the claims were still alive against Grid and Life Store.
You
And
mean in the district court or the bankruptcy
in
court?
this court, your honors found that there were still claims live against Grid and Life Store. And I apologize that I
Well,
can't.
that would be true before February. We may have been reciting it in the facts
Correct.
because it was interlocutory. That's why we concluded it was interlocutory.
But this is the 2015 opinion. And that's why there was so much of a fight downstairs. They really
I
battled
know
this out.
but my point is what made it interlocutory is the claims against defendants 2 and 3 were still open. And when they were dismissed in February, then they were dismissed and that was never challenged.
Well, the July 15 opinion from this court, but I can address more. I can put that at ease for quickly.
But it's clearly not pending anymore. That's my point. Factually incorrect. The defendants 2 and 3 by the February 2014 order they were dismissed from the case.
Correct. And
nobody challenged that.
Well, I had to file the motion for clarification in this court, which is why we were brought up for oral arguments. I had to make that motion for clarification because the lower court said, no, it's dismissed. And I said, look, it says in the opinion that they're not dismissed. But I'd like to address the vacator. I've only got 6 minutes left. Rice versus Alpha, the Fourth Circuit said that when a judgment is vacated, it never existed. That it wipes the First Circuit said it wipes the slate
How does
clean.
that get you anywhere? You never appealed that. We don't need a final judgment. What we need is some place where you challenged before the case was ended, some place where you challenged the dismissals of defendants 2 and 3. It was never challenged. The case went on against defendant 1. It went to final judgment, and then it was settled. The judgment was settled. That ended the case in its entirety.
Your Honor, the Supreme Court has said.
No, I want you to address the facts. And then we can talk about the law. We understand a lot of the law, but let's go to the facts. Isn't that what happened?
Well, this court in the July 2015 order said there are still claims open. It looked like there were because of the way, only Grid had appealed. Life Store didn't appeal. And I mean, I'm sorry, Grid moved to dismiss. Life Store didn't move to dismiss. I didn't mean to speak over you, Judge Niemeyer.
No, it's an impossibility the claims existed until after February 14. They did exist before February 14, which made your appeal interlocutory and inappropriate.
So the Supreme Court in Camreta said that the point of vacator is to prevent an unreviewable decision from spawning any legal consequences. In U.S. Bank Corp, the Supreme Court said that it clears the path for future relitigation. And what it does, it says in Bank Corp, we look to notions of fairness. It's an extraordinary remedy based in equity.
You can cite all the principles, but you're not getting around the mandate and what we decided.
I understand.
We did not review claims, the dismissals of claims 2 and 3. What we did is we reviewed the claim against the substitute trustee. We vacated that order in particular and sent it back for further proceedings against the substitute trustee.
That is correct.
Okay, now, so there is those other people were never in the case. Now, sure, we vacated. You could have maybe reopened at that time, tried to, but they were dismissed and that was never challenged. My point is when you get to final judgment after the judgment against the substitute trustee, and that case was settled, doesn't that end the whole case?
It would if that judgment still existed.
Pardon me?
It would if that judgment still existed, but the Supreme Court has said that that judgment no longer exists. It says, and the point is that it's an equitable remedy, and it's an extraordinary remedy. Vacator reaches back in time and it pulls it out as if it never happened. And that's what this court has
Mr.
found.
Perry, I think what would be extraordinary is that we would countenance vacating a judgment of dismissal against two defendants who never appeared in our court in that subsequent appeal. I mean, that seems very strange, don't you think?
Well, if STS had never been dismissed and it was only Grid and Life Store, we would be in exactly the same place. Grid and Life Store would have never been able to do anything until now. We would not have had any appeal until 2021. That it would be exactly the same course because there would never been any appealability at all. But the vacator, we believe, is so strong that and
you think it reaches back to parties who didn't even appear in the subsequent appeal to defend the order of dismissal?
Interestingly, they did appear in bankruptcy court, and
I'm talking about appearing in our court.
I believe I understand what you're saying. Our appeal was only against STS. That's what started the appeal, and that was on appeal, knowing that would be reversed and vacated like it was, and that the judgment, the only separate document judgment that is necessary for an appeal, was vacated. We knew that was going to happen.
Now, look, the vacator, you keep hopping on it. We did vacate it, but what did we vacate? We vacated everything that was before us. You wrongfully appealed interlocutory order. We lacked jurisdiction at that point. When the other two defendants were dismissed from the case below, we finally got jurisdiction because the only person left in the case was a substitute trustee. We then adjudicated the substitute trustee and sent it back for a trial against the trustee. There was no claim made that the two persons dismissed, which was part of the judgment. Now, your argument is when we vacated the judgment that we had before us, that left open a claim against the two dismissed. But you don't get around the fact that they had been dismissed and nobody challenged it. And that case was finally decided in its present form, which was just against the substitute trustee, was finally decided. Now, where do we get after that case? The whole case is done. The whole case is done. You want us to go back and review the dismissal order of 2014, 8 years ago.
That's what we would have to do if STS had never been dismissed, right? Which is what the vacator does. If the STS had never been dismissed, we'd be in exactly the same place right now because we would have had the final judgment in 2021 because they were dismissed way back then. And I agree with that. It's a long time ago.
Let's forget the peculiarities of the interlocutory appeal. You have a lawsuit against defendants 1, 2, and 3. The court throws out all three of them. Defendant 1 appeals. Defendants 2 and 3 don't appeal. What do we have before us? Just defendant 1.
Correct.
And if we vacate that, then it continues against defendant 1. But we don't reopen defendants 2 and 3. That was never brought to us. Now, when defendant 1 is finally adjudicated and there's a final judgment as to defendant 1, that ends the whole matter. And now you're coming back and say, oh, I want to go back and get defendants 2 and 3 in here.
Well, we actually tried to reopen the case because the order was so bad and everything that the magistrate court did was wrong. We tried to.
What order was so bad?
The order from the magistrate court. There were so many problems with it.
But I thought you settled it.
No, what happened was after the bankruptcy issue, there was a state claim still pending, and they appealed the bankruptcy order just to make sure they were out of the state claim. That's the only reason they appealed, and we settled it after we dismissed the state claim. That's the only reason. You can ask this.
But your claim against the substitute trustee was ended with a settlement, right?
That's correct.
All right. Now, why didn't that end the case?
Because the vacator of the 2014 order left the case open again.
But you settled it. You settled the only thing that was open. We never opened up the dismissal of the other two.
We settled the STS claim. And as a matter of fact, that it wasn't ended because the order that was sent up from the bankruptcy court, the district court never affirmed that order. The case was still stayed. And I said, where's my final judgment? And they said, you'll have to make a motion in order.
You know why we had jurisdiction in the first place, in our opinion? We had it because
finality?
defendants 2 and 3 were dismissed.
I
That's the
understand.
only reason we had jurisdiction. And at that point, we had jurisdiction over one defendant. The other 2 had been dismissed and did not appeal.
Well, as I said, it is an extraordinary remedy, but all the case law says that it makes it as if it never happened. And if it never happened, it never happened.
I can't find in the record any notice of appeal by you as to Life Store and Grid in 2013 or 2014.
That's correct. That's correct, because at that point, there was only STS dismissed. And we didn't see any dismissal of Grid and Life Store. And then
Except when we invoked the cumulative finality doctrine,
that's correct.
and that was dismissed, you should have filed an amended appeal or a second appeal as to the dismissal of those, and you didn't.
Well, the way we saw it was that only Life Store had appealed. I mean, only Grid had appealed or had been dismissed. I say appealed, I'm sorry. Only Grid had moved for dismissal and had been dismissed. Life Store didn't even join the motion to dismiss. And it was.
But they were dismissed, right?
Sir?
They were dismissed.
That's what the court found eventually. That's what this court found eventually under cumulative
That's what the
finality.
district court did. No, the defendants 2 and 3, Life Store, whatever their names are, 2 and 3 were dismissed from the case, weren't they?
It didn't appear that way, but we will agree with this court that they were.
What did the February 14 order say?
It was a statement that the case is dismissed. It's a Grid had.
And they closed the case, right?
That is correct.
Now, I don't understand why you're arguing with the facts of the case. I mean, the facts of the case is the district court dismissed the 2 defendants and closed the case. Isn't that right?
Well, what actually happened was that we appealed.
No, I'm asking you,
Yes,
did the court dismiss the case and close the case?
the court did dismiss the case and close the case.
Okay, now why didn't that end it down there?
It would have if this court had not vacated the judgment. There's a requirement, and it says the Supreme Court has said there's a mechanical application required for a separate docket, a separate document judgment. And that is what's appealed. That's what starts the clock and vacator.
Did you ever challenge the dismissal of defendants 2 and 3?
I am now.
I'm talking about before the case ended.
We didn't realize they were dismissed, honestly, that we didn't realize Leicester was dismissed. We saw
What are you doing when you're reading the February 14 order? You didn't realize they were dismissed?
Your Honor, I'll find in here that.
What does the order say? You just agreed with me that the court dismissed it and closed the case.
Well, it said that the motion that by Grid is granted and the case is dismissed. And I took it that the case against Grid was dismissed and the case was still pending against STS. The judgment against the 2014 judgment that said the case is closed was vacated and the case continued. Just exactly as if only Grid had been, if only Life Store and Grid had been dismissed and STS had never been dismissed, we'd be at exactly the same place right now.
All right. Why don't we hear from your colleague?
Thank you, Your Honor.
All right, Mr. Gaylord.
Good morning, Your Honors. May it please the court, my name is Ryan Gaylord. I represent the Appalese, Life Store Bank, and Grid Financial Services. This court must ensure that it has jurisdiction over each and every appeal. The limits on federal appellate jurisdiction are meant to balance the court's interests in finality and judicial economy against the parties' due process rights in appropriate judicial review of the district court's conclusions. In this case, the appellant seeks to expand those limitations far beyond what the statutory framework will allow, and accordingly, the Appalese believe that this court should dismiss the case for lack of jurisdiction. The procedural history of this case is complicated, but despite the appellant's attempts to muddy the waters, the Appalese agree with this court that the facts governing this court's exercise of jurisdiction are very straightforward. The district court entered a final judgment on February 20th of 2014, including a separate document pursuant to Rule 58. That's at page 117 of the joint appendix. This court, in its subsequent proceedings, explicitly recognized this order as a final judgment. That's at pages 144 and 45 of the Joint Appendix, and the district court agreed in that conclusion at page 349 of the Joint Appendix. Section 2107 and Rule 4 of the Federal Rules of Appellate Procedure require civil litigants to file a notice of appeal within 30 days of the decision for which they seek review. In this case, that time period elapsed and concluded on March 24th, 2014. The appellant did not file any notice of appeal at all between February 20th, 2014 and March 24th, 2014. The reasons for this are unclear. In the supplemental brief, the appellant indicates that it was a strategic decision because she believed that her interlocutory appeal of the 2013 order was so certain to be successful that she had no need to appeal the 2014 orders. In oral argument today, the appellant indicates that this was an error because she mistakenly believed that there were still claims pending.
Mr. Gaylord, where is that in the record about the extent of success, the likelihood of success?
That's in the appellant's supplemental brief that was submitted last week, Your Honor.
Okay.
I don't have insight. But in any event, regardless of the motives, no notice of appeal was filed, and the subsequent proceedings in this court and the district court occurred as to completely different parties, literally years after the appeals period had already opened and closed. In Hudson v. Pittsylvania County, this court held that any civil litigant must appeal within 30 days of the decision from which they seek review, as required by Section 2107. And by the simple terms of that holding, this court simply lacks jurisdiction to review the 2014 orders today. I'd like to clarify two things that came up in the appellant's oral argument this morning. The appellees believe that the appellant's citations about how a vacated decision ceases to exist are not on point because they refer to vacature of orders and not vacature of judgments. And that's clear in the procedural history of this case. You know, this court can reverse an order, sending it back to the district court with instructions as to the appropriate outcome, or can vacate an order, sending it back on grounds that the decision shouldn't have happened at all, or should happen with an entirely blank slate under different circumstances. And when the appellant cites cases stating that the vacated decision ceases to exist, he's referring to the latter. That's vacature of an order. What happened in this case was vacature of a judgment. And the appellees believe, you know, that the purpose of a final judgment, especially in the context of a Rule 58 separate document, is to indicate to this court and to the parties that the time for appeal has begun. The district court essentially, with its Rule 58 judgment, places a wax seal on the case file and says, we're done here. There's nothing left to do. All claims have been adjudicated as to all parties. And so when this court, you know, in 2015 vacates the judgment, it simply lifts the wax seal to open the envelope back up and send it back to the district court and say, you respectfully, you have more work to do. Not all claims have been adjudicated to all parties because you should have reached a different outcome as to, in this case, the trustee. That doesn't mean that the other parts of the envelope or the envelope itself never existed. And to illustrate this, we simply have to imagine a criminal defendant who successfully appeals his sentence, perhaps on grounds that he was improperly sentenced as a career criminal. This court, if that appeal were successful, would vacate the judgment and remand for resentencing. An order almost identical in language to the mandate in this case. On remand, no one would doubt that the underlying conviction of the criminal defendant had been reversed or vacated. They wouldn't have to conduct a new trial for the defendant because the other parts of that envelope, the other parts of the case file that were not before this court were left undisturbed. And so in that context, it doesn't miss Mr. Perry's reference to whether the orders dismissing Grid and Life Store would have been interlocutory in between 2015 and 2021 is a red herring, right? Because by then, the 2014 orders were statutorily barred from appellate jurisdiction regardless. Just for example, if the trustee had instead prevailed on appeal in 2015, then the 2014 orders would no longer be interlocutory if the appellant sought to seek review of those orders in 2015 or 2016. But this court would have no difficulty dismissing such a challenge as untimely because it was noticed over 2 years after the time for appeal had already concluded. So that's the appellee's view of.
Is there any order or release in the file as to Life Store and Grid? When they were dismissed, was there a release sign or an order saying they're dismissed?
Yes, Your Honor. That's at page 117 of the joint appendix. After the order resolving Grid's motion to dismiss on subject matter jurisdiction grounds, the district court entered a judgment stating that the case had been dismissed and was closed. Does that answer your question?
Yes.
Am I understanding your question? Okay, thank you, Your Honor. Turning to the second point, the appellees, I want to address the appellant's argument that, which came up at the very end of y'all's conversation a few minutes ago, that because the trustee the dismissal of the trustee was reversed by this court's decision in 2015 and was not reinstated until 2021, that constitutes a new final judgment that somehow carries forward the district court's decision in the 2014 orders, making them eligible for review. And I think, Your Honors, the critical principle here is that a final judgment serves to start the appeals period for a particular party. But once that period concludes, the issuance of a subsequent final judgment as to completely unrelated parties on completely unrelated claims doesn't reopen the window or create a new window for appellate review. And this comes up in a lot of contexts.
Well, his argument apparently is that we had before us the case against the substitute trustees, and we had jurisdiction because the other two were dismissed. When we vacated the judgment against or the order against substitute trustees, somehow the dismissal orders no longer had effect because we vacated the whole judgment of the district court. And the answer is maybe we might have vacated it, but we never changed the dismissal orders or never reversed that part, and that was never before us. All that was left in the case at that point was the substitute trustees, and we ordered specifically in the mandate that was all that was going back. So that could not be aggrandized under our mandate rule. The district court only thereafter had jurisdiction to adjudicate the substitute trustees. And the only way that he could have benefited by the vacator on a broader scale was to have appealed the dismissal orders of the other two defendants, and he never did that. But that's conceptually what I think we have before us. And let me ask you this. He got a pretty good sized judgment against the substitute trustees. Was that all the damages that were provable? And why is he seeking more relief against the other two parties?
Yes, Your Honor. And the appellees believe that was the full extent of the damages. And this is apparent from the terms of the statute. Section 362.
Well, you need to argue it. I just wanted to know if your position was that he received all his damages in that trial.
That is our view.
And I'm trying to wonder why he's making this big effort to go back now and reach and get the other two defendants when he's already been restored or made whole by the damage judgment.
It is confusing, Your Honor, especially given that the appellant's opening brief at page 17 of that document specifically states that he is entitled to monetary relief against Grid and Life Store on the basis of the exact amount of monetary damages that he received from the district court against the trustee. In the appellee's view, this means that federal claim under Section 362 is clearly moot as to the appellees because the district court considered the evidence, concluded that the appellant had incurred about $21,000 in actual damages and about $109,000 in attorney's fees, and it awarded her those exact amounts. Contrary to the appellant's assertion, there weren't three different violations of the bankruptcy stay in this case. there was one violation of the stay in which the three parties were allegedly involved in varying capacities. And so to the extent that, the appellant seeks to establish new damages on appeal as to Grid and Life Store, first, it's contradicted by the record and the district court's factual findings, the bankruptcy court's factual findings as to damages. Second, it should be considered waived on appeal because it wasn't, those damage figures weren't mentioned in the appellant's opening brief. So, the appellees believe that even if the appeal were timely, even if the notice of appeal did properly designate the order from which the appellant seeks to appeal, this court still lacks jurisdiction and should dismiss the case because there's no case or controversy before it. There's no basis for damages against the appellees in this case.
Is the better doctrine, if we were to agree with you, is the better doctrine to dismiss this because the appeal wasn't taken in 30 days as required by rule and statute, or that the plaintiff forfeited any claims against the other two by not appealing the initial order?
The appellees believe the proper basis for dismissal would be untimeliness pursuant to Section 2107. That's a statutory threshold that the appellant must clear before this court could even assess the merits or the substance of her damages claims against the appellee. So that would be the threshold step in the analysis, Your Honor, in our view.
Your colleague on the other side indicated that our 2015 opinion somehow, somewhere, which I haven't seen yet, gave some hint that there were still live claims remaining against Life Store and Grid. And do you see that anywhere in the opinion?
No, Your Honor. And I mean, the appellees believe with Judge Niemeyer's suggestion that if the 2015 opinion was going to adjudicate or affect our legal rights or liabilities in any way, including liability for, facing a potential appeal, then we should have been given an opportunity to receive notice of that appeal, appear in this court and make arguments and address those.
Well, there was an amicus, but I suppose you wouldn't be satisfied with that.
Well, the amicus, well, it's a separate issue, but it's not relevant to what's before us today. I suspect my guess would be that what the appellant refers to in terms of the indication of remaining claims is this court's order in August 2014, which is at page 121 of the joint appendix, in which this court initially dismissed the appeal as to the trustee as interlocutory. The appellees feel that this is, this court's decision.
Well, at that point, there were claims still pending.
That's incorrect. I don't believe that's correct, Your Honor. That was in August 2014, 6 months after the dismissal of Grid and Life Store in February 2014.
Oh, I see. I got you.
But it doesn't ultimately matter, Your Honor, because
what did we say in our initial dismissal for lack of jurisdiction?
This court held in that case, in that decision, that the appeal of the dismissal of the trustee was interlocutory and that it should be dismissed on those grounds. At
that point in time, there were open claims against Grid and Life Store.
Not in August of 2014. That was 6 months later.
You're missing my point. When we dismissed this appeal for lack of jurisdiction, he had appealed only the order against substitute trustees. There were open claims still pending against two others. That's why it was interlocutory, and we dismissed it. He then asked for reconsideration of that, and we applied the cumulative finality doctrine because the other two had been dismissed.
Yes, Your Honor.
All right.
And in any event, it doesn't affect the finality of the district court's judgment because...
That isn't my point. I'm trying to figure out why he thinks claims were pending, and the claims were pending when he filed his appeal. And those claims were thrown out in February of 2014. And at that point, only at that point, did we have jurisdiction under the cumulative finality doctrine, which is sort of a catch-all excuse to let a person stay on appeal when he improperly appealed.
I believe we're in agreement on those facts, Judge Niemeyer. I see my time is winding down. Just one last point to address the idea, as I referenced before, that the district court's new final judgment in March 21 carried forward the dismissal of Grid and Life Store from 2014. This is meritless, I think, under the plain terms of this court's holding in Calderon v. Geico from 2015, where it held that prior interlocutory orders are rolled up and appealable from the final judgment, of course, because you can't appeal them before then. And Judge Richardson wrote some helpful guidance on that point in the West Virginia Pneumonicosis Fund case that is cited in the Appellee's supplemental brief. But this only applies to, and this is from Calderon v. Geico, interlocutory orders from which no appeal lies. And so any attempt by the appellant to say, oh, my appeal from the final judgment in 21 includes the 2014 orders, which became interlocutory with the reversal of the dismissal of the trustee, is meritless because those orders were not interlocutory orders from which no appeal lies. Those were final binding dismissals of the appellees that this court and the district court both agreed.
Well, he wants to try to get some comfort from the vacator of the appeal against substitute trustees. But the problem with that is that at that point, the Grid and Life Store were already out of the case, and that had never been appealed, and we never addressed it. And the case was now pared down to one defendant, and we sent it back for proceedings against that one defendant. And that's all that was in the case at that point.
Yes, Your Honor. And the appellees believe that that's clear from this court's mandate in 2015. And to be clear, there's no equitable component to the analysis here. Appellate jurisdiction is governed by statute. There's no exception. There's no excusable neglect. This court has jurisdiction under the terms of the statute, or it doesn't. And although this rule isn't necessarily negotiable, it does fit with the balancing of interests in this case. Because at the time of the final judgment, the appellant had no idea how this court or the district court would rule on her pending challenges to the dismissals of the various parties, including her motion for reconsideration, her interlocutory appeal of the trustee, and so on. And at that point in time, as Your Honor has suggested, she had a very simple and clear opportunity to obtain appellate review of the dismissal of Grid and Life Store in February 2014, and that's filing a notice of appeal within 30 days before March 24th, just like any other civil litigant is asked to do. And in this case, on the facts of this case, the appellant is clearly familiar with the levers and gears of the federal courts. She was filing immediate interlocutory notices of appeal from the prior district court's prior orders in this case. She filed a petition for mandamus with this court. She filed motions for reconsideration. This is not a party who's being left out in the cold because she's overwhelmed by the confusing procedural posture of this case. Instead, she elected to proceed, instead of directly appealing the dismissal of the appellees, she elected to proceed on her pending appeal as to the trustee. She was entitled to this choice of litigation strategy, and it ended up being a highly profitable one for her. And so, to safeguard these important statutory principles of finality and due process, it's important the appellees feel that litigants only get one bite at the apple when it comes to appellate jurisdiction. And that, it'd be a judicial overreach in this case for this court to exercise jurisdiction when the relevant claims were dismissed over 8 years ago. The appellant completely failed to designate the order that she seeks review of in her notice of appeal. And she has already recovered the full amount in controversy as requested by her complaint. And accordingly, the appellees respectfully submit that this court must dismiss the appeal for lack of jurisdiction.
All right, thank you.
Thank you, Your Honor.
All right, Mr. Perry.
A couple things, Your Honor. We would argue that vacator is as strong as any statute, but if the court will direct its attention to JA 123, I found the footnote. Now, this happened in August 27th of 2014, and it says that it is possible to cure the jurisdictional defect. However, because at least some claims against defendant Life Store Bank are still pending in the district court, a final order has not yet been entered. And that's the ruling of this court in August 27th of 2014. Their claims were still open according to this court. But I would also like to address the argument that she was made whole. And the bankruptcy court found that she was not made whole. First,
Well, that isn't really before us. It was a curiosity to me. It seems to me that after you got this, what appeared to be a fairly fulsome judgment, then all of a sudden you decide to go against the others. That's not before us, and
I understand, but I feel like it would affect the court's decision, and she was not made whole by a long shot. One of the problems was the house that she was living in burned to the ground, and we didn't have documents to prove damages, which we've reconstructed some since then. But the court found on page 471, the court said the plaintiff most likely failed to prove the true extent of her damages, but she did show entitlement to a significant award. Not only that, but the defendant, the appellees are trying to say that 362 can be, STS can satisfy the 362 damages that would be filed against Life Store and Grid. That would be a huge due process problem because punitive damages are exacted against an individual for intent. How could STS be punished for Life Store and Grid? She wasn't made whole by a lot. Not only that, there's emotional distress caused by the two defendants. She had to buy her house back after all of this, and she had closing costs. And while she didn't have her house, it was a flower farm. They took the topsoil off the farm, so she's got to fix that. There are many damages that were not considered by the bankruptcy court. She's not been made whole at all. She only got $20-something thousand for her farm. We would say that again, I would say that the vacator rule is as strong as any order about a dismissal.
Well, I can't, for the life of me, understand. Your opponent says that there are orders of dismissal against Life Store and Grid in the record. Why is that not conclusive?
Because they were vacated.
Who vacated? They weren't parties to the appeal.
This court vacated the only judgment, the only separate docket judgment that was required by Rule 54 and 58. 58 says there must be a separate document, and that is what is appealed.
except we vacated only the order against substitute trustees in our mandate. That's all we did.
Your Honor, you vacated
The judgment was now narrowed. The district court had no authority at that point to go beyond the mandate. So if we had the full judgment and vacated the full judgment, we sent back only a part.
So looking at the timeline, STS,
No, I'm saying a 2015 order opinion.
we only appealed the STS dismissal because that's all that was fully dismissed. There were still claims against the other two. You can't. We said it. We couched it as an interlocutory appeal. We requested an interlocutory appeal. Then, as that was happening, there were two other orders the lower court was dismissing on grounds that this court found absolutely untenable.
Well, the court couldn't possibly do that because Life Store and Grid were not parties to the appeal in 2015.
Right. There was only STS on the appeal, and Grid and Life Store were still in the case. And the lower court dismissed Grid and, they dismissed Grid and Life Store for one motion on certain things. And then there was another motion made by Grid for saying that we didn't have original jurisdiction on a 362 claim in district court. Of course, there's jurisdiction there. And so then when only Grid filed a motion to dismiss, and this court found in August that there were still claims pending against.
Didn't we vacate? We reconsidered that one, didn't we?
No, Your Honor. That's why it got sent back. That's when you told me we couldn't appeal and you sent it back.
Just listen to what I'm just saying. I'm just looked at that. That's a per curiam order that did not apply the cumulative.
Correct.
And you asked for clarification of that.
Yes.
And we reopened it and applied cumulatives.
At that point.
So that opinion was overruled or changed. We did reconsider it.
Okay.
Because it was factually not totally correct.
So what we're determining today is how strong is vacator. Because the Supreme Court has said that the point of it is to make an unreviewable decision wiping the slate clean, leaving an unreviewable decision from spawning any legal consequences.
Well, why didn't you appeal the February 14 order when the court dismissed the claims, closed the case, and instructed the clerk to close the case?
That's an excellent
Final
question.
judgment, entered a separate document and closed the case. Why didn't you appeal that?
Because I, as this court, thought there were still claims pending against Grid and Life Store.
Well, how could there be if they dismissed them all?
We all thought the same thing, Your Honor.
I said, why did you, I didn't ask you what you thought. I said, why did you think it was open when the court closed it?
Because only Grid moved for dismissal, and the way the court stated the order, it said the case is closed. It didn't say that the Grid and Life Store are dismissed. It said the case is closed.
And it closed the case and told the clerk to close the case.
They did. But they also
That makes it pretty.
But this lower court has made some other mistakes. For instance, they never gave us a final judgment in 2021. I had to move the court, and I'll be honest with you, I called up, I thought they accidentally closed it. The clerk called me and yelled at me, said, "You've got $125,000. What more do you want?" I didn't know he was the gatekeeper for this case, but they left the stay on, and they closed the case without a final judgment. So he said, "You'll make a motion in order." I said, "Okay." So I filed the motion. They reopened the case, and he then affirmed the bankruptcy court. She'd already sent an order up. They just didn't even bother affirming that order. So finally, they affirmed that order and gave us the only judgment that exists in this case. The only separate document judgment under Rule 58 and 54 happened in 2021, and we immediately appealed that.
Mr. Perry, can I ask a question about our opinion, July the 2015 opinion? You rely, I think, on the credo paragraph where we say the judgment of the district court is vacated, and you argue that that somehow vacates the judgment as to all defendants. Is that right?
Yes, Your Honor.
Okay, so if we had been a little bit more specific and said that the judgment of the district court is vacated as to the trustee, the order is reversed as to the trustee, would you have any argument?
I would have no argument.
So, but of course that presupposes that we actually have the authority to vacate the entire judgment. And what is our authority for doing that?
I can brief that, but I don't have that answer for you right now. I know that the court has authority to vacate it. And again, as I said,
as a general matter, sure. But the
Correct.
question is, in this case, given the procedural history that's been outlined here, what would have been our authority to vacate the entire judgment?
it is based in equity. And in equity, because of, if you look at those lower courts orders, when they did things like they added in the balancing test, that was a lawful alternative explanation, and they said that there was no 11 USC jurisdiction in district court. I mean, there were some terrible decisions in that this court absolutely overturned every single part of that order. And in equity, the court reached back and said, no, we're going to keep going. Those dismissals were absolutely unfounded in any way under law. And so this court, we believed, reached back and said, the whole judgment is done. We're going to do this right. And if you dismiss these defendants, you dismiss them under law. And that's what we were going on, have been for 9 years or 8 years. Because it's based in equity. And it was unequitable for those orders to stand and dismiss these defendants on law that did not exist. The idea that 11 USC has no original jurisdiction in district court. The idea that they dismissed the state claims based on that. And this balancing test under Iqbal Twombly, none of that was right. None of it was fair. None of it had any basis in law. So yeah, when this court came back,
it's a little troubling that you've merged all of that, because really what was before us, the initial flaw was your appeal on the interlocutory, which created a procedural problem. But let's assume that we had all three defendants dismissed in a single order. That was what the February of 2014 order was tantamount. It closed the whole case. Everybody was dismissed. And only the substitute trustee appealed to us. And we vacated the judgment that was before us, which was as to the substitute trustees, and sent it back.
all right,
The others were not in because they never appealed. They were not before us, and we could not adjudicate any claims with respect to that. And that's what our mandate reflects. In the mandate here, we addressed only the October 1 order.
I understand that. So what happened? We were on appeal with STS. That was ongoing appeal while the other two were dismissed.
They were not on appeal. Would have been dismissed. It became subject to jurisdiction when the other two were dismissed. And then we had jurisdiction. So the effect of the February 14 district court order was to say, Fourth Circuit, you have before you an appeal by substitute trustees. You do not have appeals as to the other two. They've been dismissed from the case.
Your Honor,
and nobody appealed those.
If you will look at the timeline, you will see that the pending order, the pending appeal, I'm sorry. The appeal was pending against STS while those other orders came out. Right, and then
that's what cumulative finality is. You understand that doctrine, don't you?
I do understand that, but the appeal was ongoing against the STS. It hadn't been kicked back yet. And we knew it was an interlocutory appeal. We requested an interlocutory appeal because it was such a bad order. And we requested that, and those other dismissals came during that. And as I said, the only grid moved to dismiss, and this court thought the same thing we did in August of 2014, that
look,
there were still
give up on that order. We vacated that, reconsidered it, and wrote our opinion in 2015. You get no benefit from that per curiam one-page order.
Correct.
Okay.
Yes. But in the equity, we're saying
we're not in equity. We're in the court. We're under the rules of procedure. And we have rules about what's final and what's not final, what's before us, what's been waived, has to be filed timely. These are all rules that have to be followed. And when we issued our opinion, it was absolutely clear we were addressing substitute trustees and sending it back for trial with respect to them, and did not address the dismissal of the legitimacy of the dismissal of the other two.
And the 2014 order did not address LifeStore because only Grid had moved to dismiss. Your Honor, the Supreme Court said in U.S. Bancorp that equitable principles are implicit in vacator. That's exactly why there is vacator, is based in equity, and it's an extraordinary remedy.
Thank you.
Thank you, Your Honor.
Yeah. All right. Thank you. This has got a complex history. We'll sort through it and review what you have done, both with your briefs and supplemental briefs. We thank you for that. Our procedure normally now would be to come down and greet you. That's an old tradition of the Fourth Circuit, and we're very proud of it, and we have not abandoned it. But because we're still under some protocol rules under the pandemic, we're not going to come down and greet you today. But we do thank you for your arguments, and hope you come back and don't hold against any of us our tough questions.
No, Your Honor.
We appreciate your arguments.
I would like to say that I brought my daughter today. I just wanted to present her to the court.
Oh, please do.
Reagan Perry, and she just wanted to see this process.
Well, welcome, and you tell in your report, you indicate how persuasive, how persistent your father was, how sophisticated his arguments were, and you can say anything nasty about me, about my questions. I'll be all right.
Thank you, Ron.
Yeah. Have a good day. We'll proceed on to the next case.
Was she drawing us back there?
Yes, sir. She's an artist. She was sketching.
Did she get my profile, I hope?
have Mr. Heyman by remote. Is that it? Can you hear us?
Yes, Your Honors.
Okay. And we have Mr. Starosel. I have to get this right. Staroselsky.
Yes, Your Honor.
Thank you. In the courtroom. And we'll start off by hearing Mr. Heyman first and see how this works, this combination remote in court proceeding.
Thank you, Your Honor. May it please the court, I'm William Heyman. I represent the appellant, Mark Johnson, in his appeal of the judgment in favor of the SEC issued by the United States District Court for the District of Maryland. That judgment imposed a disgorgement remedy against Mr. Johnson, as well as a civil penalty against him for violations of the Securities Act and the Exchange Act. This case, given its facts, presents a great opportunity for this court to provide guidance to not only this court, but to courts around the country on an issue that was left open by the Supreme Court in its decision in Liu v. SEC. That is, when and under what circumstances applying traditional equitable principles, as the court instructed in the Liu case, a defendant who violates the securities laws can be required to disgorge funds received by one of its affiliates. Now, given these authorities in the Liu opinion, which I will discuss, and as further discussed by the authorities in the amicus brief that was submitted in that case by the authors of the, some authors of the restatement of restitution, which can be found at page 92 of the joint appendix, the district court committed an error of law that should be reviewed de novo when it essentially reasoned that if an entity is controlled by a control person, that control person must disgorge all profits received. Not only that the control person received as ill-gotten gains in his pocket, but also all profits, ill-gotten gains received by the control entity. That's the core of our argument. If the court agrees with that position, then for reasons I will explain, the penalty determination cannot.
Let me just ask you for a little clarification, which focuses on my outlook on this disgorgement remedy. As I understand, what the Supreme Court is making clear is that disgorgement is an equitable remedy and that it is basically retrieving ill-gotten gains. And to that extent, the effort of the court must be to focus on the money and the notion that there's joint and several liability in the abstract would seem to be inappropriate unless the ill-gotten gains were gotten by both entities. And in this case, if the facts show that the money was really obtained by Mr. Johnson and placed in these various entities, the disgorgement remedy would be basically tracing that money to the entities and to him and disgorging it all. It's not as if the entity independently received money for independent conduct and Mr. Johnson has to disgorge that. I think the Liu opinion seems to suggest we have to focus on the money and you clearly can't have double payment and you clearly can only disgorge from the person who received it. And it seems to me the argument that the SEC is making in this case, or the commission's making, is that the entity received the money through him and it's all really part of the same stream of entity. I mean, it's like an entrepreneur receiving money and giving it to his daughter to hold until he needs it. And then he argues, I don't have the money, my daughter has it, and therefore I can't disgorge it. I think that's the SEC's argument. I may be wrong, but I place that out to you just to modify a little your assumptions, because your assumptions seem to lead to your argument conclusion inevitably. And so I think you have to go back and look at the whole notion of what disgorgement's all about. That's probably the effort we ought to be discussing.
Yes, Your Honor. Thank you, Your Honor. This question and the factual question that you just raised is a good one. What happened with
Just a minute. Could you hold on one second? The screen, Ricky, the screen has a white square in front of it. It's blocking. Is there a way we can get rid of that?
You might want to stop the clock while you're
Yep.
doing it.
Yeah, we'll give them a little extra time. You see that square there? That's perfect. That's wonderful. Thank you. All right, we have not punished you with any loss of time on this.
Oh, thank you, Your Honor.
No.
I did reserve 2 minutes for rebuttal.
Yes, sir. No, you keep going. You've got plenty of time still.
Thank you, Your Honor. The question that you ask about the facts and what happens with the money is a question that was raised below. And I want to be clear about one point, which is we're not saying, although traditionally in equity a long time ago, tracing was required. In other words, there needed to be a tracing of the raise in order to get, at the time it was restitution. And you can look at the admiralty cases cited in lieu, and you can see in those cases that if someone did not have the asset, they did not have to disgorge. That's no longer the law, and that's not what we're saying. What we are saying is that in this case, the entered into a consent judgment with the pro se defendant. And in that judgment, the government said, this is what we're going to go after. And the consent judgment is in the record. The consent judgment has no reference to control person liability being a remedy. And in answer to your question with respect to historical principles of equity, the fact is that one looks to what the wrongdoer received. And that is what Judge Learned Hand said in the MGM, the Sheldon MGM case. And
But what happens if, as a factual matter, a salesperson speaks fraudulently to a customer and obtains money and then directs that money to go in the bank account of one of his subsidiaries? He said, I want you to make the check payable, deposit it by or electronically into that bank. And then when it comes time for disgorgement, he says, I never got the money. The bank has it. Is that money subject to disgorgement under your understanding?
My understanding, that money in that case would be subject to disgorgement. The fact that the person no longer has the raise, no longer has the property, would not prohibit the disgorgement. Although, when you look at it in the global context of what courts did, and I will come back to this, again, if you look in the Sheldon v. MGM case, which is at 106 F. 2nd 45, in that case, the corporate defendants did funnel money to a partnership that they controlled. And what Judge Hand said, and this was affirmed by the Supreme Court, was that there is no ability to disgorge that money that flowed out. But that's not the facts in this case. I would point to docket 86 in this case. I did not cite the whole thing in the joint appendix. But in this case, it's extremely clear. This is at page 3 of the Security and Exchange Commission's supplemental briefing on remedies. At the bottom of page 3, and also in the declarations that they submitted by their own CPA, there's no question, there's no ambiguity here as to what Mr. Johnson received. And that's why this case is different than the example that you just made, Your Honor. If Mr. Johnson had been responsible for monies coming into investors, into his own bank account, and then he used it for his own benefit or he sent it to his wife or to his sister or to whomever, yes,
Well,
disgorgement.
what if he sent it to a subsidiary, a wholly owned subsidiary he formed and controlled and directed the money to go to the subsidiary, and he could pull that money out at will and move it to another subsidiary, or he could move it back to his own bank account later? Is that a different factual circumstance?
That is a different factual circumstance than the ones of this case, because in this case, what the SEC argued below and what the facts show and that they cannot controvert now is that they initially requested $2.2 million in disgorgement from all the defendants. And then they said, after the Liu decision was decided, they rebriefed the issue of remedies, and they said, this is the amount that is not legitimate business expenses and that has to be disgorged from the company. And they're in three categories: advertising and promotion expenses, event and trade show fees, and airfare. And that's what they submitted in evidence. So there's $524,000 and some change, okay? Actually, it's down to the exact dollar, $524,591 that the SEC has said was not used for legitimate reasons. But none of that money went to Mr. Johnson. The only money.
Mr. Heyman, I'm sorry. So early on in response to Judge Niemeyer's questions, you indicated that you weren't suggesting that the SEC would necessarily be limited to tracing and deciding whether or not disgorgement is appropriate. But isn't that essentially the argument you're making here? I mean, you're saying that because the SEC merely traced and admitted to a specified amount with respect to your client, that's the end of the story. But the problem here is that the evidence of record also shows that he was the control person for this corporate entity. And so it would be logical to assume that in addition to the amounts that the SEC has specifically linked to your client, that there were also additional amounts that were funneled through that corporate entity writ large that he too should be responsible for as a matter of disgorgement. So what's wrong with that?
I think respectfully, there's a logical fallacy there. To say that logically he received the money that went to the corporate defendant when the facts show otherwise. Now, the fact that someone is a control person, and we brief this, does not mean, and the fact that someone can control the accounts and move money, does not mean that he's the alter ego, does not mean that there should be a piercing of the corporate veil or anything of that sort. And the fact is, what Liu says is that a defendant should not be required to disgorge more than his ill-gotten gains. And in this case, I understand your Honor's point, but we know, we don't have to guess. We know what he got. Out of the money that came in, the government has said this is all that he received, $156,963. He didn't receive any benefit beyond that. So in the Supreme Court's decision in the Kokesh case, the court made clear that disgorgement is a penalty.
In this case, is there any evidence that he moved funds from Owings to Owings' subsidiaries?
There is evidence that funds were moved between the different Owings Group subsidiaries and the relief defendants in the initial Vizzy declaration. However, the government took all of that into account when it did its analysis. So I would respectfully
my follow-up question on that is, when the funds were moved, was that under his decision-making and power? In other words, he had the authority to move among the corporation's assets, including using corporate assets for his personal expenses as needed, didn't he? That's in this case I'm now asking about.
Well, he did have that authority. There's no question about it, but there's no allegation in the case, particularly at the motion for judgment stage, that he exercised that authority improperly other than with respect to the $524,000 in expenses. The SEC has said the rest of it was legitimate. And in fact, I do want to make sure I have time to speak about an old case, but it is important in this history, which the district court did not want to hear. Respectfully, Judge Bennett was pretty clear on that. He believed, and he cited to a case from the 1990s from Judge Blake, SEC v. Resnick. He believed, as happens in many of these cases, that a control person, because they can control the account, they've got to disgorge whatever the company got, even if.
Well, let me ask you this, Mr. Haven. Didn't Lew hold that courts may impose joint and several liability for, quote, concerted wrongdoing? And wasn't that found in this case?
On a concerted wrongdoing was not found in this case. What was found was that Mr. Johnson was a control person and he controlled the entity. But I would point this court to its decision.
Well, the entity can only act through its agents, right? I mean, a corporate entity is an abstract notion that carries out its conduct through its agents. And in this case, his agent happened to be Johnson, wasn't it?
Correct. However, the monies that went to the Owens Group, according to the government's own case below, were used for legitimate business expenses, except for $524,000. So if we did not know.
But that wouldn't make them not ill-gotten gains. The fact that you spend it on legitimate as opposed to illegitimate. In other words, the question is whether the gains were ill-gotten and whether they should be disgorged as assets controllable or by Mr. Johnson if the entity that had the assets was somehow part of the wrongdoer, as the Supreme Court observed in Liu.
Well, they are ill-gotten gains. However, the Supreme Court in Liu has made clear that if the gains are used for legitimate business expenses, then they do not get disgorged. So if the court would say, even the district court below recognized that, and that's why it held that Mr. Johnson was jointly and severally liable to disgorge $524,000 plus the money that he received. I see I have 1 minute left, but the court said I could have a little more time. So I do want to make sure the court is aware, just historically, of two things. One is Nelson Salabis v. Morningside Development, which is a case from 284 F 3rd 505. That's the one case that we located from this court that discusses the practical partners concept. And that case was a copyright case. Your Honor, may I go over? I just want to be respectful of my time.
Yeah, well, we'll give you an extra minute. You also have rebuttal too. So why don't we give you an extra minute on direct? And we didn't use up that much time. We stopped the clock when we did the.
Yes, Your Honor. So
okay.
There are two points. One, Nelson Salabis, in that case, the court, it's similar to this case. There was an owner of a company that breached a copyright or violated copyright laws by taking architectural plans. And the owner controlled the company. His name was Turner. And the court vacated the decision of the district court because there were no facts in the decision that went to show that there were practical partners. It's not addressed. And if the court looks at the district court's opinion, the court will see that there is a statement about what the law is and concerted partners, but there's no discussion about whether Mr. Johnson is a practical partner. And that was error. In addition, I do want to make sure that the court is aware of the famous Elizabeth v. Pavement case, because in that case, there was an agent. And if one looks at the Supreme Court decision, it looks like, oh, the agent just got a salary. So therefore, what the court said was the agent does not have to disgorge that salary. But I would respectfully ask the court to look at the district court opinion which preceded that case, which is American Nicholson Pavement Company v. Elizabeth. It's at 15 FCAS 691. In that case, it is important to see the wrongdoer, this agent who was referenced in the Supreme Court opinion, the agent was actually control person. They didn't use that term at that time, but he was controlling the patent violator, and he owned the patent violator. And the court still said he did not have to disgorge. That's traditional equity. And respectfully, if one looks at Liu, there are such limitations.
Well, I think Liu intended to preserve traditional equity notions. And I think the idea was that we really do have to focus on the assets received by the defendant, ill-gotten gains by the defendant. And I think the question here is whether assets in some entity he controls is part of that. But I think the idea is still to preserve the equitable principles. Well, let's move on to the Mr. Gaylord, and we'll get back to you. Not Mr. Gaylord, excuse me, Mr. Samselsky, and we'll start. Staroselsky. I'm going to try to get that right. So we'll move on to him and come back to you on rebuttal. All right, Mr. Staroselsky. You can give me a better pronunciation, I'm sure. I apologize.
No, that works great, Your Honor. Thank you so much. Just want to make 2 points at the outset. First about the test, and second about the fact. So the test, Judge Floyd, you're exactly right. The court said that there could be collective liability imposed when there's concerted wrongdoing. And kind of on the flip side of that, what the Supreme Court was concerned about was a situation like in Belknap, where a defendant does not participate in the profits obtained from the violation. And the court talked also about the Contarinas case, where the Contarinas didn't control the profits. He didn't control the disbursement of the profits. The profits accrued to another entity. But turning to the second point, that's nowhere near the facts of this case.
What do you understand to be the meaning of concerted wrongdoing? How would you describe that in other words?
I think the idea, and I think there's a distinction drawn in some of this court's case law as well, the distinction between concerted wrongdoing, when they really act together to produce the violation, and as a result of their joint action, you sort of can't figure out when the money comes in who got what, so the equitable justification for apportionment there breaks down.
Well, how does that play out with a corporation? In other words, a corporation is a closely held corporation, has Mr. Johnson as the principal control person, and the corporation is a separate entity. What's concerted action mean in that context? I mean, the corporation is really only acting through him, isn't it?
Yeah, and I think, Your Honor, that's actually what makes this a straightforward case, that makes this case in the heartland.
Well, then that would make every corporation subject to disgorgement, regardless of the notion of concerted wrongdoing.
No, Your Honor. Well, but there has to be a concerted wrongdoing between two violators. So here, what we have here, it's almost a species of this concerted wrongdoing. It's kind of like the narrowest possible instance of that, because he's conspiring with himself. And just to go back to the facts briefly, the idea that Mr. Johnson didn't benefit from these funds that went to Owings is completely counterfactual and contradicts his consent. He agrees in the consent that he controlled Owings and the bank accounts. And I think this is crucial. The reason that the money goes to Owings in the first place is because Mr. Johnson wanted to conceal from investors that he's the one pulling the strings. And the reason that he sets this up this way is he'd recently been convicted of securities fraud in another scheme. And so he wants to obscure from investors that it's not that he's in charge here. That's why the money comes in. As in terms of what happens with the money, Mr. Johnson argued in his opening brief that there wasn't commingling, and we demonstrated our response that that's just not the case. he commingles money going in and going out. So when the money comes in, it's all pooled in Owings' bank accounts. And then when the money comes out, my friend just conceded he commingled the money among the various entities. He also sent money to MJSC, which is Mark Johnson Shell Corporation. He sends hundreds of thousands of dollars there, and then sends some of that money back. Now, it's true that in the revised declaration of Ms. Vizzi, we took a very, very conservative tack, and we really tried to separate the legitimate expenses from the illegitimate expenses, and we landed at a conservative number. But Ms. Vizzi is not making a legal judgment about who should be deemed to have received that money. She's just separating profits from legitimate expenses. And
What are legitimate from non-legitimate? How about if he doubles his salary? Is that legitimate?
So that's an example from the Liu case that an exorbitant salary is an example of an illegitimate expense because it's just a gain under another name. The test from Liu is you have to, for determining what's a legitimate expense, is you look to, is it a gain by another name? And that's exactly what we have here. My friend has conceded.
What if the corporation buys a yacht for itself to entertain customers?
I mean, I think it could be a fact-based judgment. Here, you don't need to reach any of that because he's conceded that it's not a legitimate expense. And the reason he concedes that is because the expenses that we're talking about, they weren't permitted by the offering document. So I think, I suppose you could imagine a situation where a yacht is what investors contemplated their money would be spent on. That's not the case here. And there's no dispute about the amount of the net profit that we're trying to disgorge. There's my friend just conceded again in his presentation that tracing isn't required. And I think that essentially decides this case.
Counsel, go ahead.
Is it problematic that the district court failed to explicitly consider Johnson's financial condition, but clearly did so for the other defendants?
So I think that gets at the civil penalty determination, Your Honor. I mean, I do think the court did consider his financial condition. And if you look at the hearing, the court pressed our counsel very strongly on that. The court wanted the civil penalty to be proportional. The court recognized that it could have imposed a much higher penalty than it did, but it didn't want to be overly punitive. And so we think the court properly exercised its discretion in that regard. When he got to analyzing the factors, he didn't even mention Mr. Johnson in the financial condition, but he did explicitly say about the other two defendants because he didn't impose a penalty on them. Your Honor, I read that discussion to include Mr. Johnson as well. Now, the judge focused on the other defendants because he wound up there. They had much lower degree of scienter. And so the court, for that reason, as Your Honor said, didn't impose any penalty on them. But the court, we think, did take Johnson's financial condition into account. That's why he received a much lower penalty than what he could have been ordered to pay.
So Mr. Heyman's first argument is that being a control person standing alone is not sufficient to warrant disgorgement in a typical case. Do you agree with that principle that by itself isn't, I mean, you're arguing that there's more here, I know, but is it the government's position that moniker by itself is enough?
We're not asking the court to go that far, Your Honor. And as we put forth in our brief, there are two paths that the court could take here to affirming the judgment. One is under the control person liability provision in Section 20A. Even there, the control person is entitled to a good faith defense. And if the courts are quite clear that 20A isn't insurer's liability.
Well, I mean, with respect to that, there's an argument that the government waived that analysis.
Sure, Your Honor. I mean, and I want to be clear, we think it's available to the court. But if the court has any question about that, we're completely fine with the court analyzing this case under lieu as well. And
So under the statute, is that all that's required if we were to take that view? Just control liability standing alone?
well, the statute says that the control person shall be held jointly and severally liable, shall be liable jointly and severally with and to the same extent as such control person, unless the controlled person makes out a good faith defense. I think there could be, we cited case law that even when you have Congress channeling a court's exercise of its discretion, there's still a reservoir of discretion for the court to impose a remedy that, so long as it's not inconsistent with the purposes of the act. So I think, maybe there are some cases out there where you do have a controlled person, but just looking at the purposes of the act, joint and several liability might not be appropriate. And I think, the key animating purpose of the act was to prevent evasion.
Is it a problem that Section 20A was not mentioned in the Johnson consent judgment?
Your Honor, I don't think that's a fair reading of the consent judgment. The consent says that solely for the purposes of the disgorgement motion, the allegations of the complaint shall be accepted as and deemed true by the court. That's at paragraph 3 of the consent. And part of the allegations of the complaint are the control person allegations. I mean, that's what this whole case is about, is the consequence of Mr. Johnson's status as a control person. So I don't think that he can, escape liability on that ground.
So I wanted to follow up on Judge Floyd's question regarding the civil penalty, because there's two issues there, right? There's the issue of whether or not the district court actually considered Mr. Johnson's financial condition. And I have to say, like Judge Floyd, I'm a little bit flummoxed by the fact that the district court spent so much time talking about that in the context of these other two defendants and said zero about it with respect to Mr. Johnson. So that seems to me to be problematic. But then there's a separate issue, the fact that the penalty in this case mirrors the exact amount that was imposed as a matter of joint and several liability. And you've got these cases that suggest that that's just not appropriate. So can you address that?
Certainly, Your Honor. So on the first point, again, I do think, and I think the district court held a 2-hour hearing on this because it said it wanted to suss out these issues. I think the court deserves the benefit of the doubt. And if you look at the opinion, what it says, all of the defendants made an argument about their financial condition. And then the court says, in light of these considerations, here's what I'm going to do. Yes, the court focuses on the other defendants because they're less culpable and for other reasons. But I think, giving the district court the benefit of the doubt here, I think the court did take his financial condition into account, which is why we're at a lower penalty award than we requested, dramatically lower. In terms of the second point Your Honor made about the amount reflecting the total sum received, I mean, a couple of responses. First, the statute says that you can calculate penalty based on the gain to such defendant. And for all of the reasons that I was saying earlier, that's exactly what's happening here. The gains come in to owings, but they're properly considered the gain to Mr. Johnson. And even if you want to think about them being technically discrete, we've cited case law as well that courts recognize that multiple defendants can benefit from the same amount of gain. Beyond that, I think this is where we're back at 20A. The general case law says such defendant precludes joint and several liability, but the terms of 20A are expressed and they govern here.
Well, as a follow-up to Judge Diaz's question, what about the mirroring? I mean, they're identical amounts.
Yes, Your Honor. So what the court was doing is it recognized at the hearing, and I believe in the opinion as well, that it had discretion to determine the proper amount. And it doesn't want to just pick a number out of the blue. It wants to pick a number that is meaningful, that that instantiates Congress's purpose in having civil penalties. And the purpose is, it's a well-recognized framework in commission cases. First, you take away the defendant's ill-gotten gain. That's what disgorgement does. And then the civil penalty is a financial disincentive on top of that. And the court looked at the number of Johnson's disgorgement liability as a guide, but that was perfectly permissible for the court to do. That's a very reasonable approach. It could have looked at the number of violations and just done a statutory penalty. We would have been over, there's 50 investors, the statutory penalty is in the neighborhood of $150,000. We would have been over $7 million in that circumstance. Under the terms of the statute, under 20A, it could have held him jointly and severally liable, not just with the entity, but with other individuals. But that's not what it did here. It took a conservative approach, and we think that was perfectly reasonable.
Anything else?
No, Your Honor. We ask the court to affirm the judgment. Thank you.
All right, Mr. Heyman, we'll hear some more from you.
Thank you, Your Honor. The first point is that counsel referenced the ill-gotten gains. I, again, would ask the court to look at Liu's warning about transforming any equitable profits-focused remedy into a penalty. The only gains that Mr. Johnson received are $156,000. The fact that he is the owner, the managing member of an entity, and like other owners of companies can move money between affiliates, does not mean that a corporate veil should be pierced or that money that goes to the companies goes to him. If it would be commingling, if investors' monies went directly to his bank account, or if he was using the company's monies to pay for his house or his boat, but that's not what the evidence is in this case. Respectfully, I would ask the court to look at what Ms. Vizzi said and what the government said. With respect to Section 20A, of course it's a waiver. You cannot not argue something below and then come in on appeal after a pro se defendant agrees to a judgment in which that does not appear in the judgment and say, well, this is a basis for an award. And I would also point out that with respect to Section 20A, the statute also limits the remedy that can be given to what's in equity. That was prior to the National Defense Authorization Act amendment of the statute, and that is the current law under the new statute. So in equity, again, what will be happening if the court affirms Judge Bennett's decision will be to impose a penalty, because Mr. Johnson will have to pay out 4 times more than what the government's evidence shows that he received. That and is the point that I feel from the questions may be being missed. Just because money goes into a company does not mean that the control person receives that money. And the last point I would like to make, Your Honor, is in a case cited by both parties, SEC v. First Jersey Securities, and this isn't a point that was made by the Second Circuit. In that case, the question was, in that pre-Liu case, whether a control person could be required to disgorge just the amounts he withdrew from the firm that he controlled that was involved in a securities fraud, or whether he would have to disgorge everything that the company got. What the court held that he would have to disgorge everything that the company got. But there's an important point that it made at page star 74 of the Lexis opinion. It said, the contention that this control person should be required to disgorge only amounts that he withdrew from the firm might be more persuasive if he had owned less than all of First Jersey stock.
Mr. Heyman, let me ask you this. In that consent judgment, didn't you concede to all the allegations in the complaint?
Yes, Your Honor, he conceded to the allegations in the complaint. The consent judgment, however, has a description of what the relief should be. So in other words, he conceded that he was a control person. And then the court sent it, he agreed, and if the court would bear with me, this is at page 63 of the joint appendix. The court shall determine whether it's appropriate to order disgorgement of ill-gotten gains and or a civil penalty pursuant to section 20D of the Securities Act, that's 15 U.S.C. 77 TD, and then of the Exchange Act 78 UD3 and section 209 of the Advisors Act. They didn't cite to section 20A. And the government drafted that judgment. And I'm not trying to say this is a game of, it's not a game of gotcha, but it's not fair to take any defendant and to say, this is how you're going to be judged to determine what you have to pay back. You go argue for 2 hours before the district court and you don't raise this issue, and then come in on appeal and say control person liability controls. And again, I would point out, we've argued this in our brief, there's a real tension there. If someone is a control person, does that mean that if that person made no money from the scheme, but the company made $1 billion, that he has to disgorge $1 billion? That is the logical conclusion of what they were saying. Returning finally to First Jersey, and I appreciate the court's time. In that case, the court said, well, if Mr. Brennan was not the sole owner, then we wouldn't necessarily have a disgorgement remedy with respect to the corporation's profits. In this case, the district court did not address the fact that, as a matter of fact, Mr. Johnson was one of 3 owners of the Owens Group.
Does the record show what his percentage was?
It does not, and unfortunately, we're stuck with the facts that are in the complaint that the SEC drafted, and I think they should be binding on the SEC.
Well, the complaint talks about controlling, so I would assume that he has the ability to carry the majority at least.
At the majority, but he did not. Well, again, I'm stuck with the record as it is, Your Honor. But the fact is, and again, I would say if the court looks to Judge Learned Hand's opinion with respect to what he did in the MGM case, there is an argument that if someone is a partner, and I appreciate the court's time. This is so interesting, so I appreciate the court's time. Thank you. If there is an argument, someone is a partner, of course, money that goes to the partnership is attributed to that partner. That's what Justice Thomas was talking about in his dissent in lieu. In this case, however, what the government is saying is, because he's an owner, without respect to how much he owns, he has to disgorge everything that the government says went to the corporation. And finally, I would like to close.
Finally, 3 times, so this is your final.
Yes, Your Honor. I just want to close again with the amicus brief. Because the authors of that brief, particularly from the University of Virginia, they're the real experts on restitution. And what he said, this is at page JA 128, is it is settled that in the great run of cases, each defendant is liable only for his own profits. The court should not recognize an exception for practical partners who are not legally partners. Belford, which is a case discussed in our brief, should be disapproved to that extent. Apart from that, Belford is one more example of a wrongdoer's liability for profits pursuant to a general grant of equitable jurisdiction. So respectfully, that's all we're asking the court to do, is require Mr. Johnson to disgorge his ill-gotten gains, $156,693. Respectfully, thank you, Your Honor.
Well, thank you, Mr. Heyman. We appreciate your willingness to proceed on remote. I know the circumstances required it. And thank you, Mr. Staroselsky, for your arguments here. We normally come down and shake hands, and we are unable to do so under our current protocols, but we'll return to it. We invite you back on this case or other cases, and we will shake your hands. Thank you for your argument. We'll take a brief recess.
Thank you.
Thank you, Your Honor.
Brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. We'll now proceed on to the case of United States versus Baronet and others. What do we have? Total of 8 defendants. And we'll hear first from Mr. Klepper.
Thank you. May it please the court, and it's good to see everyone in person. I'm here representing Dennis Pulley and the other 7 defendants. I'll be arguing on everyone's behalf for issue 4, the courtroom closure, and then on issue 6 for Mr. Pulley's particular issues under the Greer case. The founding generation put the right to public trial in the 6th Amendment, and it is fundamental, not a technicality. And Justice Black said that without exception, all courts have held that an accused is at the very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged with. And so closing the courtroom, even partially, is a very big decision because this is one of those errors where the only remedy is a new trial. It is structural error. So the district court has to be sure.
The briefs spend a lot of time, and I guess you're going to go that same direction, talking about closure. And I would much prefer to see us arguing about the limitation on access, which I think there are a lot of distinguishing factors. In other words, a lot of the principles for closure are not existent in a restriction of access. And so the question is, there was a restriction. I think we all agree here, the courtroom wasn't closed. It was, if you have 1,000 people out in the courtyard wanting to come into the court, we're not going to let them all in. So the question in this case is whether the restrictions were justified. And I'd like you to, if you argue policies or historical policies, that you keep it to that and not the total closure. We understand.
Understood, Your Honor. And I actually intend to focus almost entirely on the nature of what would be called in the parlance a partial closure. Now, the key to the government's argument is don't worry, courtroom 7D was available for audio only overflow. And the defendant secured a ruling at the beginning of trial that an objection for one defendant was an objection for all unless anyone opted out. And originally, Judge Blake said you have to opt in. And the attorney said, does that really work with 8 defendants? She said, you're right. You just have to opt out. And so October 8th, after day 9 of 25, Mr. Harrison moved for a mistrial in full, not just as to him, submitting affidavits, not just from his friend, Ms. Hamlin, but from Mr. Floyd's mother, Ms. Darnell, saying they and at least 7 others were refused at the courthouse door. And Ms. Floyd's mother, a state employee with no criminal record, was refused admission. She said, the courthouse security asked me which courtroom I was going to. I told them I was going to courtroom A. They informed me that the courtroom was at capacity and they were not letting anyone else in. When I expressed my frustration at not being allowed in the courtroom to support my son during his trial, I was told that they were just enforcing the rules and I was asked to leave the courthouse. Not directed to courtroom 7B, denied access. And who was arguing on the afternoon of October 3rd when this happened? This was not a government, this was not an informant. This was not somebody who was cooperating witness. It was Joseph Dembowski, a forensic chemist with the DEA, who started at 2:22, right before this turnaway happened, and then followed by Task Force Officer Mark Neptune.
Well, the closure wasn't from witness to witness, as I.
It was not. It was not, Your Honor.
It was a generalized restriction on access based on some reasons observed by the court in the courtroom.
Well, that's the problem with it, Your Honor. So let's look at the case law on what is termed a partial closure. I'll skip forward to that, which is, so there is the English versus Artuz case from the Second Circuit, cited in our opening brief. In that one, the defendant's family was excluded during one witness's testimony, even though the witness wasn't afraid of the defendant's family. Structural error, new trial. And here, this was a blanket, overbroad restriction because let me give you another example, which is the United States versus Cervantes case, which is the main case on which the government relies. Because all these cases have talked about, okay, did you still allow the family to be present? Did you still take those measures? Because in the Cervantes case, the emphasis was that it was a short duration. It wasn't the entire trial. It was just during voir dire. And they said, and even during voir dire, they made sure, I think there were as many defendants in that case as this one. And they said, well, each defendant gets to have 3 family members present. And the rest of the time, the defendants got to have family members present. And that is why in the government's lead authority, there was no new trial order. Family wasn't kept out, as we know happened here.
So let me ask you about the timing of this. So are you saying that the defendant's mother in this case, once she was kept out that day, never returned? Or, I mean, what happened?
No, a record was not made, Your Honor, in that point. There was no contrary record made. So here's what happened. Our clients came forward with evidence from witnesses, affidavits, saying, we are willing to testify more if you hold a hearing. The motion requested a hearing. The follow-up motion a week later showed that this had happened again with a request for a hearing. And the issue is that was this trivial? That's what the cases have focused on. Is it trivial? And is this narrowly tailored? Is the deprivation trivial? And is the partial closure broader than necessary? And what happened here was that the trial judge was made aware that this 25-person first come, first serve was causing family members to be excluded or close friends who are treated the same as family under the case law. So let me give you an example, Judge.
So I'm sorry, before you get to that. So,
no.
And what did Judge Blake do in response?
Nothing.
I mean, did she rule on the motion for mistrial?
She did not. And the government didn't file an opposition. She did not hold a hearing. She did not rule on the motion, and the government didn't file an opposition.
When did she give that big list of reasons why she restricted the courtroom? That was not initial. That was later.
That was day 3, I believe, Your Honor.
Day 3, and she explained what she was doing and why.
Yeah, and there was a foundation of that was that there would be an overflow courtroom that would be available. And then she was presented with affidavit evidence that it had not been made available. The second motion, the renewed motion, said, I found out about the overflow room, and I said, can I go to the overflow room? And so we don't have one of those open. Could you call on the walkie-talkie? He called in, and the courthouse security said, I'm sorry, I'm not authorized to open another room right now. And so this wasn't being applied the way that was contemplated. So even if we were to talk about the initial ruling being correct, Rule 51 all requires, Your Honor, the Supreme Court has been very clear about this, including in recent cases. Rule 51 doesn't require you to get a ruling on your objection. You just make the objection. That's it. That's Rule 51. It was made. It was in writing, which there's no, in the ECF era, there's no question this made it to the judge. Other ECF motions were filed and ruled on during the course of the trial. There was no hearing held. There was no ruling made. And
so a follow up to that. So, but there were people in the courtroom when it wasn't, as you have conceded, a complete closure. So is there some case law that somehow heightens, there's a heightened test for exclusion of family members or others?
Yes, Justice Black's opinion that we cite in our cases, and let me get you the site on that. That is In re Oliver, 333 U.S. 257, 1948 opinion by Justice Black. Without exception, all courts have held that an accused is at the very least entitled to have his friends, relatives, and counsel present, no matter with what offense he may be charged.
And how do we know that he didn't have friends and other relatives present at the time?
Well, here's what we do know. The mother had been in the courtroom. This is Mr. Floyd's mother, had been in the courtroom. She left because she needed to pick up the granddaughter and came back and was excluded. And we know that family members were being kept out. So let me give you an example, Your Honor.
The whole trial?
What's that?
Was she there the whole trial?
That is not in the record, Your Honor, because
she was there earlier that day.
She was there earlier that day, Your Honor. However, what I'm saying is that when this evidence came in and it was submitted to the court, that is a hit the brakes moment. And the reason for that is because it's structural error if you don't stop, make sure that it's being applied the way it's applied.
I'd like to explore that a little more.
Yeah.
I understand closure of the courtroom is because of a lot of reasons. I mean, that's what makes the United States different from some of these third world countries where we don't know what's going on in the judiciary. But here we do. I mean, the courtroom's open and there's a large trial and everybody knows what's going on. What we're doing is restricting the size of the audience for reasons given by the district court. So my question is, if the court restricts the size and does so, puts over limits on the restriction, is that structural error? And I'd like to know what case says that.
I would say, in terms of the size, there aren't that many cases on this particular issue, Your Honor. I will say the English case. It goes back
to my point. There are 1,000 people outside the courthouse and the courtroom only holds 200. So they let in the 200 and the Supreme Court, lets in people by lottery.
Exactly, Your Honor.
So my question is, it clearly can't be that it's structural error to exclude people.
It is not structural error in that sense, Your Honor. Well, actually, let me take that back. Here's what I'm trying to say, which is every case that has gone through, this is the Cervantes case, the DeLuca case, the Bell case, the Snyder case. These are all cases that have involved where the courts have been assured that family was not excluded during this period of time. If you're going to have these
first come, first serve, you tell the family to show up. If they don't show up on time and they come late, now there's no more room. In other words, I understand the frustration and I understand the whole point. What I'm resisting is the notion that we have this black and white structural error notion when the limitation rules that the court applied aren't perfectly enforced. And if we accept the fact that the court is entitled to limit, as it did, the only argument you're making, it was carried out imperfectly.
Well, the problem with it, Your Honor, was that the design, first come, first serve, is not designed for family members. These are working people, Your Honor. The mother
here is that. Why isn't it designed for family members?
What's that?
Why isn't it?
Because a lot of people have to go to work and were going when work was done for the day.
Well, she was there in the morning before that, and my assumption is that if she was that interested that day, she was there every day that she could be there.
Well, Ms. Hamlin was somebody who was coming after work. This was the friend of Mr. Harrison. These are people who, you need to, let me give you an example, like the United States versus DeLuca case, Rhode Island mafia trial. The concerns that were that Judge Blake was trying to address at that moment, these were issues where it was a mafia trial. There were concerns about bribery, witness intimidation. Instead, what they did was they had a list. They asked for ID. They came in and was designed to make sure that the people who the Constitution protects their presence, particularly under the Sixth Amendment, this isn't a press issue under the First Amendment, that this is a restriction that's designed to have those people, the family of the accused, present. I see I'm down to 2 minutes. I would want to make sure that I do not neglect my client's issue under the felon in possession point, because we were waiting on that decision in Greer. If the court doesn't have further questions on the public closure at this time, I would say that Mr. Greer was charged felon in possession of firearm. That's the indictment. An argument in Greer and the opinion in Greer, it says felon, 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 felon. And an argument in Greer, the government said the rule is unnecessary for any defendant who has a plausible argument why a knowledge of status instruction might have mattered at his trial. All I need is a plausible argument. Well, I've got more than plausible here. The government said in its opposition brief, well, Mr. Pulley was a felon, and he knew it because some of his sentences were more than a year. We don't know if he served more than a year, but that's enough. But overlooked, my client was not a felon. He was a misdemeanant. The State versus Frazier case, in our reply brief, I argued that one where it's impossible, not impossible, but you need a lawyer to advise you.
Use the word felon, does it?
What's that?
Does the federal statute use the word felon?
It does not.
Yeah, it says that it's 1 year, and then in the definitions that if it's a state offense, which is labeled a misdemeanor, then it has to be a sentence for which the sentence is more than 2 years.
Yes.
And we have a sentence, Mr. Puglia had a sentence for 3 years. He was sentenced for 3 years in one of his
I
misdemeanors.
don't think that's the case, Your Honor. I could be wrong on that, and I can hold.
He was sentenced to 3 years, and they suspended all but.
I see what you're saying, Your Honor. But the thing is that ordinary people see the signs that were posted along I-83. Are you a felon? You're found with a handgun. You're in prison. The point is that felon and misdemeanant are very different concepts. You need a lawyer to advise you.
Use that. The law uses misdemeanor only in connection with a state offense that's labeled as a misdemeanor.
Yeah.
And his offenses were labeled misdemeanors. But then it says the statute is satisfied if the misdemeanor could be sentenced for more than 2 years. Well, he actually received a sentence for 3 years on one of his misdemeanors. And so my question is, would that be enough?
No, it's not, Your Honor. And if that is the case, Your Honor, the government's concession in Greer means nothing. It means nothing, because as long as a lawyer could tell you you're a prohibited person based on what you did, which is
he was told he was served 3 years. The ignorance of the law is not the issue.
there was no record made that he was told that as a result he could not have have a weapon.
Yeah, but REAF makes clear you don't have to know the law. You just have to know whether you were a felon is what they talk about, whether you were a person in that status.
As I said, Your Honor, in that case, I think the government's concession in Greer incorporated into the Greer opinion has no meaning. I will reserve for rebuttal.
Okay.
Thank you.
Let's see who we have next. I guess we'll have Mr. William.
Guillaume, Your Honor.
Guillaume.
Thank you.
Yeah.
May you have the court's brief indulgence. May it please this honorable court, my name is Alfred Guillaume, and I've been appointed to represent Mr. Linton Broughton. Today, I'm going to be discussing the substantive and procedural unreasonableness of Mr. Broughton's and Mr. Terrell Sybil's co-defendants' respective sentences. Your Honors, as this court's decisions in the trio of cases, Ross, Webb, and Lewis make clear, a sentencing judge is to give an individualized assessment of the non-frivolous mitigation factors raised by defense counsel. It's noteworthy, I think, in this case that two of this court's decisions, Webb and Lewis, were issued after each gentleman had been sentenced. They were sentenced in mid-2019, and the Ross case was decided in January of 2019. On behalf of Mr. Broughton, the defense raised 4 mitigation arguments that were not addressed, individualized by the court. 1, that Mr. Broughton was lead poisoned as a child. 2, that Mr. Broughton was placed in special education since elementary school. 3, his lack of family structure or support growing up. And 4, that he grew up in a drug-ridden and impoverished neighborhood. With respect to Mr. Sybil's, the counsel raised 2 arguments. 1, the childhood trauma that Mr. Sybil's underwent, particularly having drug-addicted parents and having found drugs in his possession as a young child from his parents. And 2, and most importantly, his severe cognitive disabilities. The judge in Mr. Broughton's case did not acknowledge 3 of the mitigation arguments at all on the record. Judge Blake did acknowledge the fact that Mr. Broughton had been poisoned as a child by lead, but failed to offer a sufficient individualized assessment of that issue. And with respect to the other 3 issues, she did not address specifically, but rather mentioned that Mr. Broughton had somewhat of a tough upbringing, but that's an insufficient assessment of those particular very specific issues on behalf of Mr. Broughton. With respect to Mr. Sybil's, Your Honors, I think Webb is very instructive. In Webb, similar to in Mr. Sybil's case, the defendant was given a life sentence. In Webb,
let me go back to Broughton. I'm just looking here at what the court said, and the court said, I'm taking into account everything in your memoranda, as well as what was said today. Of course, the evidence at trial and the pre-sentence report, which I'm adopting. Certainly, there are mitigating circumstances about Mr. Broughton's childhood, the possibility of unfortunately lead poisoning, just difficulties in how he was brought up. I certainly understand that. I understand that undoubtedly he has done some good things in his life as well, and he's here convicted of. And she goes on to then say why she doesn't follow those. Now, doesn't this indicate the judge heard your points and considered them and actually took them into account? Because she said she did.
Your Honor, with all due respect to Judge Blake, I believe that she just simply addressing the points did not suffice under the trio of cases that we've cited.
He says, but there is a very significant need to protect the public here, to recognize the significance of the offense as well as to deter. I believe Mr. Broughton, as well as other generally that requires a very significant sentence, despite the mitigating factors that have been pointed out.
Your Honor,
now, that seems to me that's just full consideration.
Your Honor, our position is that the specific factors with this, other than the lead poisoning, were not individually assessed by Judge Blake and fall short of the guidance the court has given.
She said she took into account what you said in your memorandum, what you said there. We don't presume that she's lying, do we?
We do not, Your Honor. But I would note that in most cases, district judges, sentencing judges will note or listen to both sides and argue or not argue, but acknowledge to counsel that they've listened to their argument and this is why they're giving their sentence that they've chosen. However, even if you look at the three cases that we've cited, the judges in those sentences, in those cases for each particular sentence, they acknowledged defense counsel's arguments, but they did not acknowledge them adequately.
What do you suggest that Judge Blake should have done?
Your Honor, I would have suggested that, with all due respect to Judge Blake, she mentioned specifically explained why her sentence, how it related to those particular issues. The particular issues being Mr. Broughton's special education, his lack of family structure, and the other issue, which was the...
I'm not sure I understand what that means, but it sounds like you're just taking issue with the way in which she weighed the various factors in this case. And if that's what the argument is, I just don't see how that gets you very far.
Well, Your Honor, looking again at the guidance the court has given in the other cases, and as I was saying a moment ago, if I can pivot to Mr. Sybil's.
This is a factual question, and our requirement is that the court demonstrate that it considered, it doesn't have to use the actual words, but that it took it into account in individualizing the sentencing. And there's a couple of paragraphs here where the court explained what it was doing, and it recognized that he's done good things. He's had a difficult childhood, but it said the crimes are pretty serious. And of course, as we all know, based on the convictions, they are pretty serious in this case.
Yes, Your Honor. And for us, the key would have been relating how the particular issues related to his conduct of which he was found guilty in this case. Her assessment was not done in bad faith, but
not a bad faith. What more should she have said? She said she considered those things, but she said his conduct requires very significant sentence despite the mitigating factors which have been pointed out. And she had reiterated some of them.
I would argue that in the trio of cases, the judges there acknowledged the mitigation arguments as well. And particularly in Webb, the court noted that.
Well, what do you want her to say? Give me a posit what she should have said further.
I think it would be, I don't want to put words in Judge Blake's mouth, Your Honor, but an individualized assessment, the way I'm reading it and interpreting it based on the case law, is that she specifically, as the judges did not do in the three cases that we cited, did not provide a specific assessment of how those particular factors influenced the defendant's conduct in the particular case.
Now, so for example, with respect to lead poisoning, that almost suggested someone would have to bring an expert into court and explain to the district court exactly how that incident, which is horrific, impacted the defendant's behavior. But there was no such evidence. It was just simply a statement that he suffered lead poisoning when he was a child, right?
That's correct, Your Honor. But I think if the court looks to if the court allow me to pivot to Mr. Civils for a moment, I see my time is, I'm at the 2-minute mark. The Webb case, I think, is very instructive. The defendant in that case was given a life sentence, as was Mr. Civils. The defendant allocated, and the defense counsel offered mitigation arguments, which the court acknowledged, but did not give, as I was saying a moment ago, the individualized assessment necessary. Particularly with Mr. Civils, the court did not acknowledge or give a good enough assessment of his particular cognitive issues, of the things that he suffered as a child, and also of his intellectual functioning, which were contributing factors in his conduct in this case, ultimately what he was found guilty of.
It looks to me, I'm now looking at what the district court said about him, and it's even more than what she said about Broughton. Now, there is absolutely no question that Mr. Civils had a very difficult and destructive childhood, that he has the neuropsychological issues that have been documented. It may have been made more likely, at least when he was a younger person as a child, that he would find himself in this kind of activity. And then she goes on and talks about the history of violence and so forth. At this point, the mitigation, the tragedy that we can all sympathize with about his childhood, that is, to me, outweighed by the need to recognize this most serious of crimes, combination of crimes that he has committed, and need to protect the public. And of course, what we had with him, multiple murders, right?
Correct, Your Honor.
Yeah. Well, again, she recognizes his neuropsychological issues and his childhood difficulties and so forth.
But what
she said, and she basically said that was outweighed by the conduct.
But what she does do as well, Your Honor, is compare Mr. Civils' situation in life, his station in life, to I'm going to call it a target audience of people that she has created, in saying to the effect that not everyone with his background commits these sorts of crimes, which we feel was an improper assessment of his situation. And Your Honors, my time is running out, and I would conclude with that if the Judge Blake had the benefit of having the 3 cases in front of her at the time she made the sentence, she would have made a more individualized assessment, which would likely have led to potentially a different result, different sentence for both Mr. Civils and for Mr. Broughton. And Your Honor, if there's no further questions, I have nothing further.
Thank you, Mr. William.
Thank you, Your Honor.
All right, I guess we'll now hear from the government, Mr. Mettinger.
Thank you, Your Honor. Jason Mettinger for the United States. Your Honors, this appeal features defendants who were part of a gang, and that gang trafficked in drugs and murder. And in fact, there were 6 people that were murdered in furtherance of this gang. We do respectfully ask that this court would affirm both the convictions and the sentences in all respects. I'd like to jump right in first to issue number 4, which my co-counsel discussed. That is the capacity limitation that the court put on the gallery. And in our view, I hear the defense asking for an absolutist rule. Essentially, if any family member of any defendant is deprived of the opportunity to see every second of the trial, it is somehow a structural error. And Your Honors, I respectfully believe that that is not the law. If we look at Bell versus EVAT, this is a 1995 case from this court, it said very clearly that courts can impose reasonable limitations for the fair administration of justice. And that is what was going on here. That was the things that Judge Blake was wrestling with.
I guess if I hear the argument being made, it is not really attacking the limitations, but attacking the notion that the limitations didn't accommodate family, or at least in some examples. What do you say about that?
Well, so I appreciate the argument, but again, I think it takes and fails to look at the other competing concerns that are here. We certainly agree that the Sixth Amendment enshrines a public trial right, but in no means do we believe that that includes what the defense is saying, that every time a family member wants to come into the courtroom, they have the absolute right to do so.
Well, did the defendants ever make a suggestion that we want at least 3 of our family members to come in? Because there are 8 defendants, 3 family members have been 24. Did anybody make a practical suggestion about it?
So, Your Honor, I don't remember that specific suggestion was made. I think there was some discussion in the record of when they were trying to figure out, well, what number should we put on this? There was a question to counsel, well, approximately how many people are going to be here on a day-to-day basis? How many people have been here before? And the number 25 was arrived at based on observations of how many people were generally here. And so I think that's where the number came from. And so I think it was sort of
some suggestion that the security officers indicated that they needed that number was what they could manage.
Well, that was also part of it, Your Honor. But I do think there was some proffer by defense counsel that generally was the number. But again, I want to get to the other concerns that are at play here, because again, we have the Sixth Amendment, no question. But there's also
that's I keep questioning. I question Mr. Klepper, and I'm questioning you. It's so easy to make this a closure of the courtroom. The closure of a courtroom is very offensive, and it's structural, and it violates the very openness of our judicial system. But we didn't close the courtroom. What we did is we limited who could come in, the number who could come in. And the argument probably is whether that was reasonable in light of the fact that there were some family members excluded. But I don't know. I don't know if you should be making a concession that that's a Sixth Amendment issue. It seems to me they have a right to be in the courtroom, or they should be in the courtroom. But it's not. We're not talking about structural error here. At least I don't know of a case that says it. Right. What we're talking about is the reasonableness of the court's order and the implementation of that order.
Precisely, and to be clear from my argument, that we believe the Sixth Amendment was satisfied here, precisely because of what you said. This was not a total closure. This was not a trial in the dark. It wasn't at all.
Closure is not the right word. It's a limitation on access because of, in this case, because of security issues. And one of the more troubling was someone reported that during a particular witness, they should pack the courtroom and with the idea of influence in testimony. But regardless, there were incidents in the courtroom. The court had difficulty in managing the security. And this was the court's conclusion. Now, the question is, in doing so, was the court unreasonable? And then how should we address it if the court was unreasonable?
Yes, Your Honor. And again, the government agrees completely that a rule of reason does apply. That's what this court's precedent says. And I think that just makes sense. And again, you're right about the very troubling things that were going on here. There were outbursts from the gallery. There was a fight in the gallery. There were box cutters that were brought into this gallery.
A table was carved with the box cutter with the initials of the gang.
And there was one very telling incident too by one of the defense counsels who expressed that when the jurors left every day, they had to essentially run the gauntlet. That's what his words were, gauntlet, that there was this big crowd of people that the jurors had to sort of go through this scrum to exit every day. And I think the judge was reasonably concerned from a Remmer standpoint of, are there going to be influences on this jury? And so again, I think the judge acted absolutely reasonably.
And ask about, so with respect to this rule of reason, would that also apply to the manner in which Judge Blake addressed the concerns that were raised by the defense counsel with respect to the implementation of the limitations? Because they argue that they raised this matter twice with the district court judge, filed affidavits, moved for a mistrial, and as best as I can tell, it doesn't appear that Judge Blake did anything in response to those concerns.
Right. So, Your Honor, here's what I can say. I do believe that the rule of reason sort of also applies to this implementation portion of it. Again, this court could find that 25 was enough and you didn't even need the overflow, but let's focus on the overflow for just a second if we have to. What we have in the record is motions filed October 3rd and 10th, I believe. And I looked through the record, the trial transcripts from the days in between there. And I don't see counsel telling Judge Blake, we're having this issue. We're having this problem. Can you fix it? Can you help us? And so I certainly understand from a record standpoint, they filed motions. Those were on the docket. And so in some sense, they were brought to the court's attention in that respect. But again, there was ample opportunities to say, hey, Your Honor, we're having troubles here. And I might have missed it, but I don't believe that I saw defense counsel tell Judge Blake, hey, this overflow situation is not being implemented.
So you're saying they have to repeatedly badger the district court?
I'm not saying they have to, Your Honor, but again, I'm just talking practically in the space of a trial. If there is this issue going on, I would think the district judge would want to be aware of it. And yes, they filed motions to that effect. But I think, again, I think had there been some notice and mention of it, it could have been remedied.
Was there
that's all I'm saying.
Filed at the end of the case for a mistrial?
At the end of the case, yes, there was. And
in that motion was the makeup of the daily attendance addressed?
I don't believe it was, Your Honor. I think they might have incorporated by reference all of the objections that they made, and therefore it was.
And the court denied that generalized motion without particularizing.
Correct. So I guess in that respect, one could say that it was ruled upon in that manner.
Well, it's implicitly ruled upon because the court didn't grant a mistrial.
Precisely. So, Your Honor, again, I think reasonableness applies. I just want to mention one other thing about the backdrop of all this. This court is aware of many instances of difficulties of people trying to influence jurors in the Baltimore courthouse. So there's the Small case and the Beasley case. These were under the Remmer situation. But this court has grappled with people trying to influence and intimidate jurors in Baltimore. And that simply cannot stand. And here, Judge Blake was trying to protect the sanctity of that jury, and she has to have the ability to do what she did here.
I think I have some recollection in the record that number 25 was offered by defense counsel.
Again, yeah, I think it was, Your Honor. I think there was some discussion as to, well, how many people are normally here? And I believe a defense counsel mentioned it's generally 25, Your Honor. So I think in some respects, this was a number that was arrived at based on input from all the parties. I do want to move on briefly to the Greer issue with regard to Mr. Pulley, because that was mentioned. With regard to what you said, Judge Niemeyer, I think you're right. We have to look at the statute. It doesn't say if they're convicted of a felony. Therefore, the
definition, to be fair, I mean,
it's punishable.
When the predicate crime is a state crime that is labeled a misdemeanor, the definition then says that you have the burden of showing that it has to be punishable. In order to be compliant, it had to be punishable for more than 2 years.
Correct, Your Honor.
So it modifies the 1 year provision in the statute to that extent when we're involved in state misdemeanor. And in Pulley's case, is it Pulley?
Pulley.
In Pulley's case, he was convicted only of state crimes that were labeled misdemeanors.
So we agree with that 100%, Your Honor. And you're right. It's in 921A20B, where we have that if it's called a misdemeanor, we have to then look to see if it's punishable by more than 2 years. So let's just look at every predicate or every prior conviction that he has.
I haven't taken a poll, but I guarantee you I could walk up to 10 people, 9 of them would say you have to be convicted of a felony. They don't read the fine print about the 2 year thing.
Well, that might be correct, Your Honor. But again, I think to Judge Niemeyer's point earlier that ignorance of the law is not going to be a defense here. And the crimes have to be punishable by more than a year. And if you look at every one of them, it beats it by a country mile. And so, we have drug possession. That's actually the lowest one under Maryland Code 5-601. That's a 4-year statutory maximum. If you look at the second degree assault, that's Maryland Criminal Code 3-203. That's a 10-year stat max. And then if you look at the attempted heroin distribution,
what's the evidence that he had all those statutes in front of him at any point in time?
Well, again, Your Honor, I don't think we have to prove that he himself saw those statutes.
But you do have to show that, and I'll just quote Greer here. It says, if a person is a felon, he ordinarily knows he's a felon, so there's that presumption. But then it says, thus, absent a reason to conclude otherwise, the jury will typically find the defendant knew he was a felon. But given this mishmash of statutes that suggests a felon is actually a misdemeanor in Maryland, why would an ordinary person believe otherwise?
Right. So the answer to that question, Your Honor, is what Judge Niemeyer was mentioning about the actual sentences that this individual received. He did receive sentences in excess of 1 year. So therefore, he had to have known that he was sentenced. I think the one, he was sentenced for 17 months, 17 months of custody for that one drug possession charge.
I think there was one for 3 years where it's suspended.
One for 3 years was suspended. So, I mean, he's being told, sir, you are sentenced to 3 years in prison. Anybody of ordinary intelligence knows that, okay, I've now been sentenced to a crime that's at least punishable by more than a year because I got a 3-year sentence. And so, I think based on that, we're very much in the clear. I would cite the United States versus Caldwell case. That's one that this court decided post Greer. That person had multiple convictions. This court also found relevant that the person stipulated at the trial that they were subject to this crime that was punishable by more than a year. And here we do have those stipulations. So in that respect, I do think there is.
What's the stipulation again?
So the stipulation by the defendant was to the fact that he was.
This is Defendant Pulley?
Defendant Pulley. And he stipulated that he was subject to a crime punishable by more than a year. And I want to be
Why do we have an issue at all then?
Well,
stipulated to.
So the reason we have an issue, Your Honor, is because Rahafe added that extra part that he had to know it.
Well, if you stipulated to it, you know it.
Well, so that would be our argument under Caldwell, that stipulation is part. But I think my friends on the defense side would say we stipulated to the fact of a conviction. We didn't stipulate to my client's knowledge of it.
All right, I understand.
And so that's the little play in the joints. Obviously, now the stipulations read differently. They read just like Rahafe.
So the knowledge has to come from the fact that he was actually sentenced to 3 years.
I think that's part of it. But again, this court in Caldwell said that the stipulation can form some basis to say that he knew.
Well, I think it's a valid point that the stipulation is more limited if it's just the fact of conviction and not the knowledge of the status.
It is, Your Honor.
And all it says is that he stipulated that he was sentenced to an offense punishable by more than a year, right? Is that what it says?
Correct.
But the Maryland statute requires that the offense be punishable by more than 2 years in order to satisfy the definition of a felon, right?
So you're right because of the misdemeanor angle.
Right. So I mean, how do you connect the dots there?
Well, Your Honor, again, we're trying to look at a plain error. Do we have some sort of miscarriage of justice here? And I think
the fact is, as Judge Diaz points out, your statement that he stipulated contributes nothing. Because he only stipulated to 1 year, and he would have to stipulate to 2 years to make it meaningful under his record. And your better argument is that he was in fact sentenced to more than 2 years. But
that's right, Your Honor. If I could put an analogy on it, the stipulation is a pebble in our argument. The big
doesn't
rock,
help your argument at all.
Well, I understand, Your Honor. I'll just say the big rock in our argument is the sentence that he received, the 3 years that you mentioned. And I think that's sufficient. I would like to move on briefly to the other issues that were mentioned, issues 14 and 16, with regard to the procedural reasonableness of the sentences of Mr. Civils and Mr. Broughton. I do believe that Judge Blake appropriately analyzed why she was imposing these sentences. She weighed those mitigation factors. As you said, Your Honor, she did say, I've looked at your memoranda, I've considered them. She did engage with them on the record. If you look at Joint Appendix 3517, that's where she talks about Mr. Civils and does weigh the childhood issues, the neuropsychological issues. She mentioned that on the record and just said, look, those issues are not outweighed. They don't outweigh this expansive and horrendous criminal conduct that this gang engaged in. And she sat through that entire trial and heard about murder, burning individuals, shooting at them, dealing drugs. She heard about all that evidence. And so therefore, I think it was quite appropriate for her to say those criminal acts outweigh the difficult childhood circumstances that might have existed here. Similarly, with regard to Mr. Broughton, that's Joint Appendix page 3458. That's where, again, she wrestles with these issues. And I believe she made a more than sufficient record of it. I think that the argument, and Judge Diaz, you kind of touched on this, and you too, Judge Niemeyer, what more should she have said? I think the quibble is really, well, she didn't have a more elongated discussion, or maybe the quibble is we didn't like how it came out, but that does not require a resentencing. That's not the standard. I think she did everything she needed to do for this court to engage in appellate review and decide that she was procedurally reasonable in what she did.
I mean, I think the cases, I haven't gone back and looked at the trio of cases that Mr. Guillaume mentioned, but at least some of them, if not all of them, are cases where the district court said nothing about the issues. And that's obviously a concern, but that's not what happened here.
100%, Your Honor. I think the cases where there are problems is the total failure cases, the ones where there is just absolutely silence on the record. And here there's not that. And so that's why I think we're distinguished from those. So, Your Honors, I think I've addressed the issues that were raised by my defense counsel here. I know there's a number of issues in the case. Unless members of the panel had any other questions about specific issues.
Yeah, I do. I have a question about the sufficiency of the evidence that Floyd conspired to kill Addison. What do you have on that?
Certainly, Your Honor. I'll just turn to my. All right. And Your Honor, this is issue number 11 with regard to the murder of Mr. Addison, you said?
It's a question of the evidence you have against Floyd, defendant Floyd, who was charged and found guilty of conspiring to murder Addison.
Right. So I think, Your Honor, we have to start first with the wiretap calls. That's the principal basis that we see Floyd's involvement. And so there's a series of calls in April of 2016.
I'm familiar with those. How about any in May?
There's one.
When was Addison murdered? He was murdered in late May, right?
Late May. So there's one on May 3rd where they're talking about Mr. Catchings teaming up with Mr. Addison. There's also one from, May 25th, but that involves Mr. Civils. That does involve Mr. Floyd, but obviously they're all in a conspiracy together. And I think if you put under, Pinkerton, I think we can look at Mr. Civils's actions as being reasonably foreseeable by Mr. Floyd. But really, it's the wiretap calls. But then the other thing that we have is that testimony of
What's your best wiretap call that implicates Floyd?
So I would say, Your Honor, the one from April 14th of 2016, it's Joint Appendix page 3140. This is where Mr. Floyd is talking to Mr. Baronet and talking about how these guys that they were looking at, murdering are over there at Addison's grandmother's house. I think that's the best wiretap call. But what I would buttress that with is the testimony of Tyree Page. And that mostly appears starting at Joint Appendix page 1685. Mr. Page discusses how he saw these individuals and overheard these individuals discussing that they were going to commit this murder, and then observed them get into a van. And then later he described the shots that he heard and things of that nature.
Was Floyd in that van?
I believe he indicated that Floyd was in that van. I believe he indicated that all these individuals were there. He mentioned Mr. Baronet, Mr. Civils. He also mentioned, I believe, Your Honor, if I'm remembering it correctly, I believe that he also indicated that Mr. Floyd was there. And forgive me if I'm incorrect about that, but I think he did. So, Your Honor, I think that's the sum and substance of what we have as to Mr. Floyd's involvement. But we also have, quite a bit as to Mr. Baronet and Mr. Civils, and I think that can be attributed also to Mr. Floyd in furtherance of this conspiracy. So I think, Your Honor, based on that, we have to construe every part of the evidence in favor of the jury verdict. And I think if you do that, I think it's reasonable and rational for the jury to have reached the decision that it did as to Mr. Floyd, as to the Addison murder.
So that was a special murder verdict with respect to Mr. Floyd. And the issue, I guess, is in the context of a RICO indictment that alleges a number of predicate acts. If we toss one out, I mean, does it really matter in this context?
So they found, multiple predicate acts. Right. And you're right in the sense that there was more than enough there to sustain the RICO conviction as to all of them, and certainly Mr. Floyd. So I think you're right about that, Your Honor. But again, I do think on this record, there is a sufficient amount to say that the jury came to a rational conclusion, and we have to respect what they did.
All right. Anything else?
Nothing from me, Your Honor.
Okay.
I thank you for the opportunity to be here.
We'll hear from Mr. Klepper.
Thank you. Very briefly, Your Honor. I'm getting back to Judge Niemeyer's point about whether Mr. Floyd's mother was there the entire time. I just want to talk if you've never had a family member on trial with the need for the other family members to hold everything together, I don't think you can really say that Mr. Floyd's mother, well, she should have been there every day, all day, to make sure nobody took her place while she was.
I was wondering, I would expect that to the extent she could, she was there. But this is just a sheer speculation, a mother and son type of relationship. And the fact that she was there, but left and then was unable to get back into the courtroom is somewhat supportive of the notion she was there from time to time. But and I asked that if I didn't know whether the record has anything about that.
Well, here's the thing, Your Honor. There was the record that a mother of the accused headed out for a moment because of childcare and couldn't get back into the courtroom for the examination of a witness where there was no intimidation issues or anything like that. And what happens, Your Honor, is that in all of these cases, including the partial closure cases, Your Honor, including the partial closure, they look to whether it was trivial. And what happened here was evidence of substantial. Because what the government has said and what the judge said at the very beginning was, here is my backstop, which is the audio only overflow. And that's important because if you're there for audio only overflow, you know when there's a break, you know when there might be a chance to go down and perhaps check if a space is opened up. And they, call the walkie-talkie. Is it open? No. The judge had concrete evidence. The only evidence in front of her was that the measure that she put in place to make sure that family members could get there if they wanted to be was not being complied with, and the courthouse security had no idea.
What did she direct in that regard?
She directed that room 7D be open for audio only overflow. That is what she directed. And the only evidence, Your Honor, was that the courthouse security was like, oh, we don't know anything about an audio only overflow room. And they turned away 9 people, Your Honor, on October 3rd of trial. 9 people, including a close family friend and the mother. And this is critical for the family where this may be the last time before their child is sent off to Terre Haute, Indiana, or something like that. It is a chance to be there in the moment of need. And this is critical, Your Honor. This is critical. I mean, when I say, have you ever been there? I say, as a child of the criminal justice system, have you ever had a parent go away to prison? I have. Have you ever had the sheriff come to take away the family car, which is being used to make money? Yes, I have. This is critical. A partial closure that says you cannot be here, and I'm using the wrong word, but I don't mean dystopian, but going in and saying, no, turn around. But we were told this is open. No, we don't know anything about it. And the judge, upon hearing that, should have hit the brakes and made a record that was trivial. And every single case from that we have cited and that the government cites, there still must be a showing of triviality when there is a known deprivation, because every single case says there is not any evidence that a family member was excluded for a key period of time. That is what is said in the case law, and this is critical, Your Honor.
Who was the witness testifying in that at that moment?
I'm sorry, what was that?
Which witness was testifying? Do we know?
Yes, we do, Your Honor. This was, I will draw that very quickly. It was the forensic chemist.
Oh, you did mention that.
The forensic chemist and TFO Neptune. These were not people like in the cases where this court has affirmed, oh, this is a vulnerable witness who might be abashed by this. This was, and the judge had learned that the safeguard that was put in place was not working and courthouse security wasn't doing it. No record of triviality was made. That is a hit the brakes moment so you can make sure and make corrections, do triviality. We know that 8 days later, after the first notice that 9 people had been turned away, the courthouse security still knew nothing about courtroom 7D supposing to be open. Called somebody, call someone. No one there. This is the kind of thing that, the family, they are there. Much of the justice system is giving the family an explanation of all of this. This is critical. And so the suggestion this is not a Sixth Amendment issue when the judge knows that family members are not allowed in the courtroom, this is Sixth Amendment. And so I just want to say that in the strongest terms, this is why we have it. It's not just Star Chamber. This is about the interest of families being there. And when this motion for mistrial was made, it cited it. Counsel cited, you are excluding family members, you're excluding close friends. This is a problem, this is structural error, and the trial judge did nothing. I'm over my time. I don't have much to say on the Addison point, the Floyd Addison point, which was brought up, but here's what I will say on this. It is a red flag when the government's citations for many of the facts are from the pre-sentence report. Pre-sentence report serves a very particular purpose in our criminal justice system, and it is not to show that there was sufficient evidence of the crimes. And so, especially now with all these spaghetti boy type things where nothing seemed to quite add up, that is something where, look, we're talking about enhancements, we're talking, this is something where the court should care about whether there was adequate evidence before the jury.
All right, thank you, Mr. Clupp. Mr. Guillaume.
Thank you again, Your Honors. Just briefly in rebuttal, I would address directly a point that Judge Niemeyer and Judge Diaz made as to what should Judge Blake have said or done differently. I would just offer that each case is going to be a case-by-case basis, and I think it will be clear from the record of the particular case of the answer to that question. So in other words, I don't have an exact words to provide you today, but I think it's an individualized assessment. It speaks to a case-by-case basis. And I would also
you really get down to, this is not a mechanical cookbook type of formula that is imposed. The whole idea is that the court give enough reasons to enable us to review what's going on and the reasons why the sentence was imposed. This is instruction right from the Supreme Court, and that's the standard Supreme Court imposed that is sufficient for us to conduct a review. And in this case, the court clearly acknowledged the mitigation aspects and then concluded that the particular conduct was outweighed that in this particular case. And so my point is, what more would the court have to say? We know the court considered it, it weighed, and it ended up at this judgment level for a sentence. So the question then we review is for abuse of discretion.
Well, Your Honor, addressing that and sort of segueing into my last point, which is another point that Judge Diaz made with respect to cases where judges were silent or hadn't said much. I would argue that Webb was not one of those cases. In Webb, the defense counsel gave very specific arguments, which were acknowledged by the court. And the fact the court said that everything that you're saying to me now goes against what your client said in allocution. And this court, in giving a life sentence in the district level, still felt that that was necessary. the reversal was necessary. And I would argue that that case, of all the three cases, is potentially the most analogous to our case here today. Your Honors, I have run out of time. If there are no further questions, I conclude my presentation.
Thank you, Mr. William.
Thank you very much.
First, let me recognize, I guess, Mr. Klepper, Mr. William, you are court appointed, and you know this is just an enormously important function. We want to acknowledge that service. This is a case where, in particular, we need good counsel because when you have a high-profile case that where the defendants are the targets not only of the courts but of the public, it's important to have good counsel, and we appreciate your service in this case very much.
Thank you.
Our practice is to come down and greet counsel, and in view of the pandemic protocols, we're still not doing that. But I think all of you will be back, and we'll shake your hands again at that time, maybe double shakes and cover. Many thanks. We'll proceed on to the next case.
Thank you, Your Honor.
Thank you, Your Honor.
Have a bifurcated presentation. Ms. Helm, can you hear me? You're in remote there, and I can see you well enough. Can you hear me?
Yes, Your Honor, I can hear you fine. Can you hear me?
Okay. Yes, ma'am. That's fine. And we have Mr. J. Are you going to be arguing here in the courtroom for the Novartis?
That's correct, Your Honor.
Yeah. Okay. Well, why don't we hear from Ms. Helm then and begin?
Thank you, Your Honor, and may it please the court. I'm Catherine Helm from Deckert, representing Eli Lilly and company entities as appellants here. This case concerns the resides or is found language in 28 U.S.C. 1782 that permits district courts to order discovery for use in foreign proceedings. The district court below found it lacked jurisdiction and reversed the magistrate to vacate Eli Lilly's 1782 application, and in doing so committed reversible error for at least three reasons. The first error is that 1782 requires or is found language was held to require a physical presence of the entity from which discovery is sought, and that under this construction, then Novartis was not found in the Eastern District of Virginia. And third, that Lilly's 1782 application should be denied based on the Supreme Court's intel factors. Now, before presenting our views on why the statutory interpretation was wrong and thus the application flowing therefrom was also wrong, I'd just like to present two sort of overarching themes that we think encapsulate the errors here. And the first one is that Novartis paints a broad brushstroke, ironically, to say that Lilly is reading a section 1782 too broadly overall, without any specificity as to the word found. That because Congress chose some broad terms, it must have wanted every term in the statute construed broadly, and that's not so, and we'll explain why that's not our position. Courts have consistently interpreted found in other statutes broadly, not just 1782, and have cautioned specifically in the case of 1782 not to engraft these atextual limits on it. The second major theme is Lilly's position is that Novartis relies on what it calls this historical understanding of personal jurisdiction law that is outdated, no longer correct, and ignores current law, statutory principles, and that this infects both the construction and the application of its argument that found requires this physical presence of an authorized agent in the district. Novartis relies on old cases, old academic commentary that were both pre.
Let me address the jurisdictional notion. I can tell you that I personally have a lot of trouble equating found with a jurisdictional notion. It seems to me they're totally different concepts, and it didn't look like Congress was extending found in 1782 to the jurisdictional limits under the Due Process Clause that govern jurisdiction. And so you can try to make the argument and I will listen, but I think that the jurisdictional reach is broader than being found. I don't mind interpreting found and hearing the full arguments on it, but I must say, if we get into the whole notion of, I mean, we have both Calder and a Burger King where it says you don't have to be present there, you don't have to be found there. It's a jurisdictional reach under, especially involving electronics now, it is remote. It's a concept that is different and I think far broader than the word found. Now, that doesn't mean I've reached any conclusion, firm conclusion about what found might mean, but I must say, my colleagues can take up their own positions on this, but I don't find a whole argument directed at jurisdiction to be helpful myself.
Okay, thank you for that, Your Honor. I think we agree that Burger King and other cases hold that the sort of antiquated notions that we might otherwise attribute to a word like found in a statute like 1782.
They didn't address found. That's my point. In other words, it's not a helpful lane. They are talking about fairness and the reach of a sovereign beyond the state lines. And they have addressed it in many different contexts. And the courts now are addressing the extent to which you market over the internet and direct your attention to a particular state. You've never been there. You have no property there. You have no agents there. There can be jurisdiction there, though, under the Due Process Clause. And but Calder is one of the typical ones that's really out there, pretty far out, I think. But Burger King made the point explicitly, and I don't think we're using different language. We're using different concepts. Here in 1782, Congress said that it almost looks more like a venue provision that you can use 1782 where the person from whom you're seeking the information, where the person is found. But you can argue it, but I can tell you, I don't find the jurisdictional language and discussion useful. It's much broader.
Okay. Well, why don't we go to what
but you can look, don't, you make your judgment call. I got two colleagues here who are just much smarter than I am, and they may be on the other side of that.
Well, let me try and temper this for both of you. I think our position is that the jurisdictional analysis of found really does import a lot of the sort of fairness considerations inherent in the question of venue and sort of what is a requirement for Congress's usage of found, and we could go to venue statutes to exemplify that. And part of our
Ms. Helm, don't you have to have personal jurisdiction over Nevada's, regardless of what the correct meaning of found is? Because you got to have jurisdiction to enforce the subpoena.
You do have to have personal jurisdiction over Novartis as a statutory matter for found. You also, since 1782, mandates that the statute and the discovery obligations therein are carried out through the federal rules of civil procedure that extends to nationwide service over Novartis. So in this particular case, for example, the subpoena that was granted from the application and issued and properly served on Novartis as an entity was served on an officer and director of Novartis in a different district, and nothing in the rules or the statute require that service be in the same district in which Novartis is found for purposes of the 1782 statute. And in this particular case, it wasn't.
Or they served in Chicago? Was that it?
Correct. Yes, she was served in Chicago and accepted service there. And under our line of cases, which we can get into, Novartis raises in several different aspects of its argument this point of where documents are located. And the district court also, we think, erroneously relied on that and sort of took up we're calling it the extraterritoriality point that was addressed in the Del Val ruling and elsewhere. And our position on that is that extraterritoriality and the actual location of the documents is not at issue here. It's not properly before this court. We should look to the federal rules for those implementations and the standard rules that apply in federal rules, 34, the sort of possession, custody, or control test of documents. And one of the emblematic ways in which documents can be found, or documents can be produced, is if they are pursuant to a director or officer speak on behalf of the company having access to those documents, which we believe.
I think what Judge Floyd was getting at, and I guess he can correct me if I'm wrong, is that let's assume that we agree with you that found extends beyond, actual physical presence in a particular district or jurisdiction, but extends to the limits of personal jurisdiction. The district court in this case determined that given the facts of this case, including the fact that the only contact that Novartis had with the Eastern District of Virginia was a patent proceeding that was simply pending, had not received any patents at the time, and that result wouldn't extend beyond the limits of the U.S. in any event, even though tangentially related to overseas litigation, that simply wasn't enough. And so that's sort of the rub here, isn't it? What's wrong with that ruling?
Certainly, thanks for the clarification. So if we're assuming that found is met as a statutory matter, I think the question is, was the test met here for Novartis in the Eastern District of Virginia? And we believe it was because of three specific reasons. And the first one is that the characterizations of Novartis having one proceeding in the U.S. Patent Office that's only tangentially related to a European patent infringement action abroad is simply not accurate. Our position here is that Novartis engaged substantively with all of the adjectives required for this fairness analysis in the Patent Office, intentionally targeted, directed, ongoing activities to purposefully avail itself of those rights of the Patent Office, that creates the significant connection between the discovery that Lilly is seeking in the 1782 application for the underlying controversy, which involves far more than one patent infringement dispute over a European patent. It involves competition, defenses, and claims that relate directly to Novartis's activities. And I'd be happy to go through how each one of our discovery requests directly tie to that. And we believe the district court erred significantly by entirely ignoring the pending competition law defenses and claims in this action. As you recall, the district court focused on and characterized the proceeding abroad as one patent infringement action. The district court also focused on pending or a potential European filings of complaints and used language that such potential complaints might be no more than a twinkle in the eye and not sufficient to rise to having jurisdiction over Novartis for its actions here. And those are simply not accurate. The facts here are rather atypical, and that's what leads to such a strong connection between what Novartis has done in the Patent Office and what Lilly is asserting in terms of fairly broad sweeping global antitrust claims. And the controversy includes, the controversy includes discovery requests that directly ask about and relate to particular acts. And those acts include the acquisition of a portfolio, which included at the time the potential for a US patent, as well as the rights to US applications flowing from that patent. And we have a request specifically directed to that, including filings made before the Patent Office, as well as US, that's request number 4. This is all at the Joint Appendix 54. The subpoena itself is reproduced several times in the Joint Appendix, but that's the earliest one. There are also requests directed to the US proceedings, as I said, that's request number 7. Valuation, including the US patent, which was formed as a part of the valuation and which Lilly did not know at the time when it originally sought its application, but has since learned and bolstered that. And that was one of our requests. And all part of this discovery was geared towards getting at conduct that impacts competition on a global scale. And Judge Davis below correctly noted this when his summary of the application and granted it on that basis was, he said, Novartis conducted itself in such a way to utilize the USPTO as a conduit through applications and other conduct that would give them a footing to remove competition concerning their product. Now, what Novartis is doing on a global basis could be used by Lilly to argue in their various pending complaints. Novartis attempts to preserve its own dominant market position, and the US is the largest market. And Novartis has made admissions, as we cited in our reply brief, which were made subsequent to the district court's decision. So the district court didn't have the benefit of this, but Novartis specifically raises that Lilly's ability to practice the patents from Novartis may also include patents that have not yet issued or that may issue in the future, from example, pending US applications. Now, there's a body of antitrust law that gets at the potential for assertion of not only existing patents, but potential future patents and invalid patents. And Lilly has done several steps to counter this in the US, I should say, including filing a grievance between the Office of Enrollment and Discipline, and that is in the record as well, that details Novartis's conduct. And it's simply incorrect the way Novartis has characterized it to say that it is no more than a handful, or in fact, they say 2 sets of filings that include recordation of assignment and 3 patent applications of ministerial consequence. That's simply not true in the record. And we can directly rebut that by now we have the purchase agreement that was made between Genentech, the party that sold this patent portfolio at issue, and Novartis that bought it. That purchase agreement begins at Joint Appendix 547. There are redacted portions of it, but there are significant portions that are not redacted. And I would just like to point you to a couple of them that directly speak to patent assignments, patent recordations, and delayed assignment agreements. And the agreement, as insofar as what is public that we can discuss, is that the acquisition of this portfolio contemplated the timing and structure and sequence of filing patent assignments as part of an anti-competitive scheme to remove Lilly from the market and to do things like give Novartis standing in Europe to file for certain claims, including seeking preliminary injunctions. Lilly's direct...
Yeah, I think you can pick up on this if you wish on rebuttal, but I think we've gone over the time here a fair amount, and so why don't we give Mr. Jay a chance here?
Certainly, Your Honor. Thank you for the time.
Yeah. All right, Mr. Jay.
Thank you, Your Honor. May it please the court. The district court got all 3 of its conclusions right, and this court can affirm on any of them or all of them. I'll go wherever the court takes me, but if it's up to me, I'll start with the statutory question and discuss why they don't get over that first hurdle because Novartis Pharma AG is not found in this district. And then I'll touch on the other 2 issues of specific jurisdiction and the intel factors. But as we said, any of those would be sufficient basis to affirm. The correct interpretation of the word found is not that it means the limit of due process. A company is not found in any district where due process would allow it to be subject to suit. Found had a definite meaning at the time this statute was enacted, and Lilly's definition is not supported by anything in the statute, in the structure, in the dictionaries, or in the case law that was on the books at that time. So we think that the district court got it exactly right by concluding that a company to be found in a district, I'll just put it colloquially, has to be found there for service of process. There has to be a presence or an agent who can be served. We think that's what this court should hold if you reach the statutory question. And I recognize that there's a lot of history and that personal jurisdiction doctrine certainly has changed since 1948. But the other side sort of uses international shoe as a stand-in for what they think the word found means. Now, international shoe doesn't construe the word found. I think this is the point that Judge Niemeyer made in his colloquy with my friend earlier. Instead, it talks about presence and recall that in international shoe, the presence in that case was a bunch of salespeople who lived in Washington, carried out sales in Washington, and were served with process in Washington. So even if international shoe itself were the test or what it meant to be present, that wouldn't help Lilly in this case. They need to go all the way to the outer bounds of personal jurisdiction. Calder and Burger King are a good illustration of when a company might be subject or a defendant might be subject to personal jurisdiction, but you wouldn't say that they're present in the district. The defendants in Calder were not present in California, even though they were held to be subject to personal jurisdiction there because they had targeted a California resident with, in that case, defamatory conduct. Lilly's other argument is a structural one. They say basically that resides or is found, that those have to mean different things. We agree with that much, but it's certainly not necessary to give is found this unnatural, indeterminate meaning in order to give it some work to do in the statute, because companies are found in lots of places where they don't reside, but that's not the same thing as saying that they are found everywhere the due process clause might permit.
We recently, I think within the last 2 years, addressed found in connection with the immigration laws. This is the proper venue as to where somebody who comes back into the country after being deported and commits a crime where he's found. And we concluded, along with the Seventh Circuit, that found means where the person is, as an existential notion. Seventh Circuit, I think, said it's the person's being where the person is. It's sort of it gets to be a physical, a philosophical notion, but it probably parroted the Supreme Court's definition in the Supreme Court. I mean, the antitrust cases where it is construed found to be where a corporation has its agents. And
that's right. For a natural person, found often means
a corporation has its agents. A natural person, it would be where the person is. And so the real question is, did Congress go beyond those types of concepts in this case when it used the word found?
Right. I think that's exactly the question. And I think that the antitrust cases that you just alluded to really strongly support our position, because Congress took the trouble in the Clayton Act to broaden the antitrust venue provision from resides or is found to resides or is found or is doing business. And the Supreme Court said in the Eastman Kodak case that clearly means that is doing business is a broader concept than is found, that a company can be found in fewer places than it might be doing business, because found is a narrower and more sort of legalistic concept. And that in the United States versus National City case that the other side cited in its reply brief, the Supreme Court makes exactly the same point, that Congress broadened the antitrust venue provision precisely because it thought resides or is found was not broad enough for the remedial purpose that it had in mind in those statutes.
Well, is it true that before 1978, did Black's Law Dictionary's definition of found require a corporation's physical presence within the judicial district?
I wouldn't say physical presence of the corporation itself, Judge Floyd, but it did require its physical presence or through either personally or through an agent, and that agent might be appointed by statute. But that's right. There had to be someone within the district.
Well, it's hard to talk about where a corporation is as an abstract notion. I suppose where it's incorporated could be where it is. But it seemed to me the Black's Law Dictionary definition had a special section that addressed corporations. Didn't it?
That's exactly right. It said that as applied to a corporation, it's to be found, it is necessary that it be doing business in such state through an officer or agent or by statutory authority in such manner as to render it liable then to suit and to constructive or substituted service of process, and to such an extent that actual presence is established. So the agent might not be the company's CEO, that it could be an agent appointed specifically to receive service of process. But to be found in a district means to have someone in that district on whom process can be served. It could be an employee, it could be an agent, it could be an office, it could be the Secretary of State if you're incorporated there. But it does not mean subject to personal jurisdiction on any of the broad theories the Supreme Court has adopted in cases like Calder. Lilly has not cited any dictionary that adopts that definition. I mean, I think the closest that they came was citing from the prior paragraph of the Black's definition, which deals with individuals. There is a line that says that it doesn't necessarily mean physical presence, but that's citing the Freeman case from the Supreme Court, in which an individual left the district after the litigation was commenced. He'd already been served and he left the district.
Well, that's the curious thing about the site, because he was present in Boston.
Indeed, he was.
And he left. And of course, jurisdiction attaches at the time of the commencement of an action.
Right. And he tried to get out of the amended complaint by saying, I'm no longer in Massachusetts. And not surprisingly, the Supreme Court didn't countenance that. So the line in the dictionary saying that it doesn't necessarily mean physical presence, I think that A, that's true for an individual, but B, that is far from suggesting that.
It's actually not true, because it's inaccurate, because it's a timing issue. The Freeman case, he was present and did not eliminate the need for presence. And the fact that he left after the suit was commenced didn't mean he was no longer present.
I agree with that.
Yeah. But we have that doctrine today in basically jurisdictions established at the time that suits commenced. When we have diversity jurisdiction, that's when we measure it.
That's right. Now, I recognize that the Second Circuit did come out differently on this question, and I would like to address that just briefly. Now, it's important to note that these arguments that we've gone through today, Ms. Helm and I, were not really made to the Second Circuit. The argument in that case that the respondent was making was that is found only means tag jurisdiction, and tag jurisdiction doesn't work on corporations, so therefore corporations can't be found there. And that the Second Circuit did not really parse the meaning of the word found. It doesn't cite any dictionaries, as the district court in this case pointed out. It just cited its own prior precedent, which said that 1782 is to be construed broadly. We don't have any quarrel with the idea that Section 1782 should be construed broadly, but the words in it have to be given their meaning. And there's no construction of the word found that goes to the full limits of due process. And the Second Circuit ultimately didn't have to confront that in that case, because it ultimately decided that there weren't minimum contacts and the defendant or the respondent wasn't subject to personal jurisdiction anyway. So its construction of the statute was just an alternative holding. I'm not saying that it was dicta, but because it was an alternative holding, it wasn't subject to further review, and the Second Circuit didn't have to delve as deeply into these arguments, which of course wasn't presented with in that case. Just touch very briefly on the other statutes that our friends have cited that they say have been construed this way. First, they're worded a little bit differently, but second, and most importantly, they don't cite any case from before 1948 that gives it that interpretation, whereas we have the Supreme Court saying, as applied to a corporation, this is what resides or is found means. Unless the court has further questions on the statutory question, I would like to turn in the alternative to why Novartis isn't subject to specific jurisdiction in this district. And ultimately, I really just want to make 2 points that my friend on the other side said today something different than they said in their reply brief. In their reply brief, they said, I think this is page 18, that they are premising their jurisdictional theory on the filing of these and prosecution of these patent applications. Today, I think you heard something a little bit different, but ultimately, I don't think that it matters because the prosecution of the patent applications in a federal agency in the Eastern District of Virginia is just not the purposeful availment of the benefits of the Commonwealth of Virginia in that district. And that is exactly what the Federal Circuit, which obviously has a considerable interest in the question of personal jurisdiction in patent cases and in the role of the patent office in it, in the Touchcom case that we cited, and said that that the Commonwealth of Virginia would not have personal jurisdiction over the law firm that was prosecuting patents, which was accused of malpractice in the prosecution of those patents. So there was no kind of germaneness issue in that case, but they said just essentially sending documents to a federal agency that happens to be located in Alexandria, Virginia, is not availing yourself of the benefits of the Commonwealth of Virginia. Now, in this case, there isn't even that same level of germaneness between these patent applications and the European litigation for which they claim to be seeking the discovery. But ultimately, I don't think the court needs to reach that if you follow what the Federal Circuit's reasoning and hold that just prosecuting patent applications before a federal agency is not sufficient.
Well, Ms. Helm says that, I don't think, well, she doesn't necessarily concede this, but maybe in isolation that may be true. But here, what we have here is sort of a concerted strategy by Novartis to stifle competition, both overseas and domestically. And that's kind of the sufficient jurisdictional hook to make this discovery relevant and to amount to sufficient context to allow for the exercise of personal jurisdiction.
I'm happy to address that, Judge Diaz. Novartis does not have any intellectual property in this portfolio in the U.S. In other words, like no patent has issued. If a patent had issued, then they could be pointing to Section 293, which is the special long-arm statute that applies to foreign patent owners. And they've tried to make use of that and to some cases that cite that, but it really only applies, one, to a patentee, in other words, someone who's actually gotten a patent, not an applicant. Two, someone who hasn't designated an agent for the service of process somewhere in the United States. And three, it's only for for proceedings affecting the patent or rights thereunder. And so that's the kind of jurisdiction for which the Eastern District of Virginia is the ultimate backstop. When a foreign company gets a patent and someone wants to bring an action about the patent or rights thereunder, and they haven't specified somewhere else where that can be brought, okay, that can be brought in the Eastern District of Virginia. Now, that statute doesn't apply here because none of the three elements are met, but I think it really goes to your question.
I mean, is that intended as a limitation or just an example of one method by which personal jurisdiction might attach?
It is the only means by which the Eastern District serves as a sort of a backstop without the applicant's formal consent. In other words, you have the option to not obtain a patent. You have the option to, if you do obtain a patent, you have the option to designate an agent somewhere in the United States. Only if you don't do that is the Eastern District kind of forced on you as a place where you are required to subject yourself to suit. And then not for all purposes, not even for kind of, purposes of, European patents. It's only for proceedings affecting the patent, the US patent, or rights thereunder. And ultimately, a US patent only has any effect within the United States. There's no such thing as a US patent that can stifle competition overseas. And if they had a claim under United States antitrust law, they could bring a claim under United States antitrust law. And the jurisdictional and venue reasoning would be quite different because under that statute's worded quite differently. But to say that these contexts, the just pursuing patent applications in the patent office gives rise to a sufficient jurisdictional connection with proceedings under European patents, just because I took this to be their point that the European patent and the American patent applications were bought at the same time. And if that's the only connection, that's certainly not enough to say that continuing to prosecute the applications that you bought gives you specific jurisdiction.
Well, I mean, not just bought at the same time, but they relate to the same drugs. Do I have that right?
They relate to the same technology in a broad sense, I think. I want to be clear, though, that Lilly has mentioned in its briefs and in the appendix pages that Ms. Helms cited, a U.S. patent that Genentech owned Novartis at no point has owned that U.S. patent that was not part of the transfer. So it's important to note that the patent that was successfully challenged in the United States, that was owned by Genentech, remained in Genentech's hands at all times. So we're only talking about applications that were assigned to Novartis, remain in COA, have not issued, have not resulted in the issuance of any patents. And indeed, some of the applications that they have pointed to have been abandoned. So ultimately, so what that means, I think, is that even if the court were to adopt the other side's reading of the statute and hold that it goes to the complete outer limit of specific personal jurisdiction, they just haven't established specific personal jurisdiction here over Novartis in the Eastern District. And I think that to hold that it did would raise some troubling implications both for patent applicants and really for federalism generally. There are the colloquial example that I can give you is that if you want to operate a Coast Guard licensed boat on the Chesapeake Bay, you have to get a license. And where do you send your license paperwork? You send it to Falling Waters, West Virginia, because that's where the Coast Guard Documentation Center is. Don't think that you're purposefully availing yourself of the jurisdiction of West Virginia when you do that.
If we find that there's no jurisdiction, do we have to worry about the intel factors?
You do not, Your Honor. You can decide these three issues in any sequence. So one is basically statutory jurisdiction, one's personal jurisdiction, and one is another threshold non-merits issue. So the Supreme Court in cases like Sinachem has said that you can decide them in any order, and I think it certainly would make sense not to decide the intel factors if you don't feel that you need to. We've emphasized that as the third issue, in part because it is abuse of discretion review, and the district court is entitled to deference in deciding that even if it had this application properly before it would not grant the requested discovery, in part because of the ability to get the discovery in Ireland, for example, early. Perhaps not.
Does Ireland have some level of discovery?
Ireland does have discovery, and just within the last week or so, the High Court of Ireland has granted Lilly's application for some discovery. I know it did not grant everything that Lilly wanted, and Novartis has likewise has sought some discovery in that action as well. And as far as in the briefing, there's some dispute about whether that could be used in other European proceedings. But I would just point you to Joint Appendix page 258, which is an exchange of letters between Novartis's Irish counsel and Lilly's Irish counsel, in which Novartis agreed that at least one document produced very early in the Irish proceeding could be used in various other European proceedings.
Can I ask about your clients' activities here in the States in seeking discovery in Indiana, I believe? I mean, is that somehow an inconsistent position here?
It's not, Your Honor. I certainly understand the question, and I understand why Lilly has sought to use it, but I think it's important to understand that the timing of it. That application was filed only after the magistrate judge in the Eastern District of Virginia had denied our motion to quash, and so it appeared we were going to be subject to discovery here. So while we were pursuing review of that decision, Novartis filed a 1782 application in Lilly's home district, basically seeking reciprocal discovery. Now, we filed a paper in that court before the magistrate judge on Friday of last week in response to a motion that Lilly had filed, in which we said specifically that Novartis would likely reconsider whether it needs to pursue U.S. discovery at all if it wins this case. So in other words, we filed that application as a reciprocal application. If Lilly is not getting discovery from us, we would likely reconsider whether we need any discovery from Lilly in the United States. So
sounds to me like this litigation is going to keep lawyers busy for a while.
It certainly is a complex dispute, but the U.S. part of it, ultimately is
U.S. is 21782 proceedings. Is that the U.S.?
There is a third one in California, but that was discovery from Genentech, which actually is a U.S. company. Yeah. And the only dispute remaining in the courts at that point is not about what will be produced, but about who has access to what's been produced. So I think that's not really relevant here. But it certainly is a complex dispute. But the U.S. portion of it is pretty narrow, and the question really is just whether Novartis should be forced to bring documents to the United States in order that they can be sent back to Europe for use in Europe, and the limitations of 1782.
Well, that goes to the Intel factors, yeah.
It does, but it certainly, I think it underscores why the court should not permit discovery from a company that is not found in the district where the application is filed.
All right, thank you, Mr. Jay. Ms. Helm?
Thank you, Your Honor. Just a few points here in rebuttal. So I think to begin with the dictionary point, doing business through an officer or agent or by statutory authority does not require physical presence. And the line in Black's dictionary about not necessarily requiring physical presence, though for a natural person, was not needed for corporations because corporations at the time were not required to be physically in a jurisdiction to be found there. We cite several of the other statutes, and opposing counsel ignores those statutes, including ones that were in the same bill at the same time of 1782 that interpret resides or may be found language to extend to the limits of personal jurisdiction. And all cases since the Second Circuit and the Del Valle case have fallen in line with that interpretation of found. Our opposing counsel cites a few district court cases pre-Del Valle that do not find that found extends to limits of personal jurisdiction, but those very districts, including the DC district, since then and since the Del Valle ruling have reversed and said that they find the Del Valle ruling persuasive and have interpreted found in that way. And that's the district, the DC district court, as well as two ND Cal courts, which have also extended the ruling on extraterritoriality that was held by Valle. As to the evidence relating to the US patent proceedings and how that's relevant to the European antitrust proceedings, I think I'll just pick up on a couple of points from Judge Diaz. I believe it's hard to see you, but you asked if this was not just, if the basis for jurisdiction in EDVA, Lilly was asserting, was not just the filing of patent applications. And you're absolutely right. And that also kind of dovetails with the whole clearinghouse argument. So I'd like to address that. Novartis changed their language from clearinghouse to magnet, probably because clearinghouse was used in Del Valle and that argument was lost. And in that case, the concern was sort of the same, that you're going to open these floodgates. Every major bank is in New York with a city full of good lawyers. Come here and get your discovery for use anywhere. And would this decision open, unbridled access to documents for any foreign patentee that files US patent applications? And that's absolutely not the case. This is an incredibly atypical and unusual situation, where the antitrust claims asserted are some of the more complex and in detailed than courts have seen in Europe. It's not the duty of the district court to have to delve into the merits of those claims. I remind you, this is as you know, a discovery provision, not a liability provision. And I think that needs to be taken into consideration when thinking about the discovery that would be for use in the underlying litigation. And the point about Section 293, I believe, Judge Diaz, you also said that might be one example by which personal jurisdiction might attach. That's absolutely right. We really view Section 293 as the ilk of providing what's called, fair warning of jurisdiction in EDVA. And that fair warning language is from Justice Kagan in the Ford case, and essentially amounts to the knowledge that a particular activity may subject that corporation to jurisdiction. And 293 provides for a vehicle to avoid that should they choose. They can file for an agent anywhere else they like. Novartis hasn't done that. So here, easy relief would be to designate an agent outside, and they did. Novartis also doesn't cite the definition of patentee itself in the statute, and nor has Novartis cited a single case saying that 293 cannot encompass patent applicants. And the definition of a patentee under 35 USC 100D is not only the patentee to whom the patent was issued, but also the successors in title. And we did bring up the US patent, which is an issue in the purchase agreement, because Novartis discussed being the successor entitled to that patent and has been the successor entitled to the lineage of patent applications that are all related. And we submit that Novartis, by its own actions, as acknowledged before the California court, and now is in the record here, is treating these patent applications as they're acting like a patentee for them. And at least one case in the Ninth Circuit considered and relied on patent applications as a strong indicator of purposeful availment. And so too here, we believe. The Touchcom case, the Federal Circuit case, we believe is not apposite here. It was a very different case involving malpractice claims, and the concerns were different. We think 293 makes the best example by which personal jurisdiction might attach here.
Tom, can I ask a question? I think I understood Mr. J to say that this appears to be a veiled attempt at seeking discovery in an antitrust case that has yet to be filed. And it's kind of like ready, fire, aim, that you're looking for discovery for purported antitrust case using the mechanisms of 1782. Do you want to respond to that?
Certainly, Your Honor. So one of the clear errors we believe the district court made here was ignoring the actual claims and defenses that are of record that have been pleaded extensively in the various foreign litigations. And as you know, from the last argument, I believe I listened to one of you had mentioned that you're aware that foreign litigations are not like U.S. litigations and that they don't all have PACER dockets, and we can't just cite our very extensive claims and defenses relating to anti-competition. But they do exist. They are of record. We have an attorney declaration from Lilly indicating that each of those jurisdictions has competition claims and defenses. They're very extensive. And furthermore, that each of those tribunals would be receptive to discovery information directly related to that to adjudicate those claims and defenses. And we don't think that the district court should have the burden of having to delve through those claims and defenses upon grant of an application. What the district court really needs to do is look to see, again, under Ford, whether there is a strong connection between the underlying litigation and the discovery that's sought. And all of the reasons that Novartis is raising for things like the burden and several of the intel factors, we submit are not the appropriate time now. This is under the federal rules of civil procedure. The appropriate time to deal with that would be, for example, in a motion to compel. And we had that at an earlier stage, and the parties had decided they were going to work out some document production, and that's of record as well. So clearly they had access to the documents if they were going to do that.
All right. Thank you, Ms. Helm. This is, we appreciate these very sophisticated arguments. Both counsel, our practice would be to come down and shake your hands, and we would very much enjoy that, but we're still following the protocols under the pandemic. And so we'll pass that, but we invite you all. Ms. Helm, we hope your circumstances improve too. We invite you back to the court. It doesn't sound like this case is going to end very soon, so maybe some part of it stays here or goes somewhere. We'll see you again, though. Anyway, thank you for your arguments, and we'll adjourn court for the day.
Thank you, Your Honors.
Case stands adjourned. God save the United States and honorable court.